Lord,
Is it granted that you give a
to be
third?
granted.
What is this kind of submission?
Lord. Be that.
That you give an adjournment, see the matter be adjourned?
No, Lordship. No,
Sorry,
Lord.
let it reach.
Wait, your lordship. Well, I beg to mention item number 30, my lord. This matter has become infectious, my lord.
3-0.
3-0, my lord.
Oh, for the other side, Public Works Department. Anybody
Yes,
there?
I have informed Gogoi, my lord.
Mr. You are there? H. Burwa? Okay. 3S Hawk, Learned Counsel for the petitioner, has submitted that by flux of time, the matter has become infructuous. Also heard, anybody's state government, also heard Sri G. Bokolia, Learned State Council, and Sri H. Burwa, representing the Public Works Department, para. This petition is accordingly dismissed as infructuous. And interim order, any?
No, my lord.
Yes.
My lord, another matter, my lord, item number 38, my lord.
3-8.
Quantum case, my lord.
Yes.
Here, my lord, I have been informed today morning, my lord. My lord, the quantum number 1, my lord, he has changed the office, my lord. So I need to implement the present incumbent, my lord.
38.
Yes, my lord. Quantum number 1, my lord.
Have you informed the other side?
Yes, yes, my lord.
3S Hawk Learned Counsel for the petitioner has submitted that he has received information that there is change in the incumbent holding the post,
Of managing
and therefore appropriate application for implement of the new incumbent is required to be filed. Para. In view of the aforesaid submission, matter is adjourned by 4 weeks
Right.
to enable filing of such implement application. Date na lage dibo, huh? Filing officer.
I am applied.
Right, and after something the environment report, please, I beg to mention item number 30. We seek some time to obtain instruction, with regard to, with regard
3-0.
1-3.
Yes, what is your prayer?
Instruction with regard to the rejoinder affidavit filed by the petitioner on 14th of July.
This 14th. Okay. Miss J. Busha, Learned Counsel appearing on instruction of 3. Learned Counsel appearing on behalf of respondent number 3. Prays for some time to obtain instructions on the rejoinder affidavit recently filed by the petitioner. Para? Matter is accordingly adjourned by 2 weeks to be listed on we'll have it on 3rd of August. 3-8.
August.
6-8. 6, not 6. 6 is Thursday. 5th of August. 5-8. Yes.
Lordship, with the consent of the other side, I beg to mention item number 28. Lordship.
2-8.
Some
Yes.
more time may be provided. We need to file the affidavit in reply, Lordship.
On a request made by Sri K. Kashyap,
Okay, sure.
Learned Counsel for the petitioner. Matter is adjourned. Matter is further adjourned by 2 weeks, 3 weeks to enable filing of rejoinder affidavit. List on 3rd of August.
After 5th, Lordship.
After 5th, okay. 7th of August.
Much obliged.
7-8. Yes.
45.
Yes. Okay, have you informed the other side? Hmm?
Malaj, I appear for
Okay.
the petitioner, Malaj.
So would like to file affidavit also. Sri M. Sharma, Learned Counsel, has submitted that he has been instructed to appear on behalf of the respondent number 6 and would be filing the power during the course of the day. Full stop. He also prays for time to file affidavit in opposition. Para. Matter also heard Sri B. Chaudhary, Learned Counsel for the
Petitioner, Malaj. My
Huh?
name is not reflected in the cause list, Malaj.
for
My
the
wakalat-
petitioner who submits, who has informed that his name has not been reflected in the cause list. Para. Matter is accordingly adjourned by 3 weeks to enable filing of affidavit in opposition. Full stop. List on 10th of August. Name of Sri B. Chaudhary be reflected in the cause list.
There's an interim order, Malaj.
Para. Interim order passed earlier to continue till the next date of listing.
I'm deeply.
It places my lord has mentioned item number 17 of the daily list.
17.
To the concern of the other side. my lord.
Yes,
I'm praying for 1 week time to file our affidavit. Motion.
yes, Mr. Sharma. On the request of Sri H. Barua, learned counsel representing the Public Works Department, matter is adjourned by 2 weeks to enable, 2 weeks will be enough? 2 weeks to enable filing of affidavit in opposition. Full stop. List on 3rd of August. 3/8, Mr. Sharma, 3/8 is okay? Sir, para. 3 P. Sharma, learned counsel for the petitioner is present.
Please, Lordship, with the consent of the other side, I beg to mention item 44, my lord.
44.
Yes, my lord.
Yeah.
Contempt application, my lord. During the pendency, they have paid a substantial amount, my lord. I want to bring those on record by filing an affidavit, my lord.
You want to withdraw this?
No, not withdraw, my lord. The part payment is left, my lord. I just
So
want.
why is it required? You are for the petitioner.
Yes, my lord.
If they make part payment, it's up to them. If it is not fully complied with,
Some,
your ADECA,
yes, my lord.
Sri ADECA learned counsel for the petitioner has submitted that during the pendency of this case, the part payment has been made towards compliance of the order in question. Full stop. He accordingly prays for some more, prays for adjourning the matter so that further developments can be apprised. Para. Matter is accordingly adjourned to be listed on 10th of August.
Yes.
10/8.
Oblige.
My lord, I beg to mention item number 31, my lord.
Yes.
I was required to file my reply to the affidavit filed by the railways.
Hmm.
My lord, may kindly take it up on 28th of July, my lord.
You have not filed.
No, my lord. It's a tender matter, my lord, so.
On the request of Sri H. K. Sharma, learned counsel for the petitioner, matter is adjourned by 2 weeks.
1 week, my lord, on 28th of July.
Matter is adjourned to be listed on 28th. 28.
Yes, my lord.
That's a Tuesday.
Yes, my lord. For the
Tender matter, my lord, stay is there, my lord.
Okay. Can we go for disposal on 28th?
yes, my lord.
Then we'll keep on. No, don't like that. Sri H. K. Sharma, learned counsel for the petitioner, prays for some time to file rejoinder affidavit. Para. Sri H. Gupta, learned CGC, has however submitted that there is urgency in the matter and there is a stay order operating. Para. Considering the above, matter is adjourned to 28/7/28 to enable filing of the affidavit in reply. Para. Interim order passed earlier to continue till the next date of listing.
Much.
May I please, Your Lordship, I beg to mention item 24 and 25.
Item
24 and 25.
24 and 25, yes.
With the consent of the opposite party, I pray for an adjournment as we require some time to file a rejoinder affidavit.
Why do you need adjournment?
Lordship, we need some time to file a rejoinder affidavit.
Rejoinder, other side has filed affidavit. You are on behalf of Dr. B. N. Gogoi.
Sure.
What is your name?
Kiran Jamia.
Please give your name. Ms. So-and-so learned counsel appearing on instruction of Dr. B. N. Gogoi, prays for and is granted 3 weeks time to file rejoinder affidavit. List on, have you taken the consent?
Lordship.
List on 5th of August, 5/8 at our order, which is. Is there any interim order? Okay, yes.
With the consent of the respondent, I beg to mention for item number 26.
26, yes.
May it be adjourned for 3 weeks as we need time to file our rejoin.
Inform the other side. On a request made by Ms. M.D. learned counsel for the petitioner, matter is adjourned by 3 weeks to enable filing of rejoinder affidavit. Full stop. Para. List on 5/8.
There is a interim order.
Interim order passed earlier to continue till the next date of listing.
My lord, in the item 1 and 2, my lord, we need to file a rejoinder, an affidavit, my lord, showing the admission of the authority, my lord.
That was granted on the first date.
First that, my lord, they have approached to the authority, my lord, it is likely to get, my lord. So I may pray, my lord, 3 weeks.
Section getting additional is that even also there no representation is also there. Nothing is there.
Three J.I. Borbia, learned counsel for the petitioner, has renewed his prayer for grant of time to obtain necessary instructions towards placing on record necessary documents showing admission of liability by the chief engineer oblique head of the department as mandated by the honorable full bench. Para. Also heard Sri K. Gogol and State Council. Para. Matters are accordingly adjourned to be listed on 3rd of August,
My lord, some more time be given, my lord.
10th of August.
Two also same.
Same order.
Metric Osterman. One 3, 4, and 7. Same minus, same out of same cause of action, man. This is what is this?
5 also, my lord.
Oh, 5 also, yes. 3, 4,
Council is required.
okay,
For several period.
9 again.
Forest names have been reflected.
Reflected here was one.
Please have the forest council, Mr. Chaudhary, after a while.
Mine.
Item 5,
May it please your lordship.
yes.
The petitioner filed challenging an order of the respondent number 5. The petitioner filed an appeal to the respondent number 3. That was not disposed of. So the petitioner being aggrieved on the inaction on the part of the respondent number 3 filed a writ petition before this honorable high court.
Hmm.
This honorable high court by the order dated
8.
8 of 2024
Hmm.
dispose of the said writ petition with a direction to dispose of the to the respondent number 3 to dispose of my appeal within a period of 45 days.
But how will it give rise to a fresh cause of action?
Fresh cause of action, my lord, the respondent authority times and again issued notice to the parties and hearing is completed, your lordship, already. Official respondents also. But till date.
It is not a
Respondent
fresh cause of action, madam.
Think about the final order,
Why
your
did
lordship.
you come up for contempt? You are just circumventing the process which is prescribed in law.
Contempt proceeding.
Contempt, the limitation has, you're barred by a limitation. How is a fresh cause of action? We don't see a fresh cause of action.
The respondent is sitting over the final order, your
So you
lordship.
should have filed a contempt case.
It takes time.
Can we adjudicate matters over and over? It has been adjudicated, directions have been given to consider the appeal. It has not been done. This direction is of 2024 August. You should have come up in contempt. Madam, you take instructions. Otherwise, technically, she may not have a case, but you should act. Who is the respondent number 3, madam?
Respondent number 3 is the secretary, your lordship. And this Secretary, Department of Revenue, Karbi Anglong Autonomous Council, Lifu.
Heard. Miss
A. Begum.
A. Begum, learned counsel for the petitioners. Full stop. The being aggrieved by orders passed in a mutation case, the petitioners had preferred an appeal before the respondent number 3, which was not disposed of. Full stop. The petitioners had accordingly filed WPC 4771 of 2022 before this court, which was disposed of on 22/8/2024, directing consideration and disposal of the appeal within 45 days. Full stop. However, the same has not been done, and accordingly, the writ petition has been filed. Paraphrase, this court is of the opinion that the petitioner ought to have approached this court in its contempt jurisdiction, and the present petition filed after 2 years clearly appears to be one to circumvent the said process. Be that as it may, let let notice be issued, returnable on 17th of August 2026. Yes, who is this? Revenue Department, Revenue names. No, not. J. Hendik, is it there in the court? J. Hendik, Revenue Department 1. Karbi Anglong, madam?
2 to 5.
2 to 5, huh? Name 2 to 5. Extra copies. Then steps for service of notice 6, 7, 8, 9, 10 by speed post with AD. Steps within 2 working days. Para maintainability of the petition is however kept open. But try to have the instructions. Get it disposed of. If they're aggrieved, they can come. Otherwise,
Right.
Forest. Yes, Mr. Gogol.
My lord, subject to my senior's convenience, I have a method division movement. Like attend and come back, let me get it.
Okay, Mr. Chaudhary, is it okay?
Oh, that comes with.
We can have it at a fixed time at
Yes,
2
take
o'clock.
time, madam.
2 o'clock.
No, yes, come now, he'll go and attend the one
Oh.
item.
Oh, it's up to you. You don't talk about your convenience to this court. What you arrange is your headache.
But now it's okay, man, he has come.
Okay.
Madam, 3, 4, 5, and 7. The petitioners, my lord, they are carrying the business, timber business, my lord. They purchase the timber, my lord.
Timber.
Yes, they bring it to the godown and thereafter, after finished goods, they purchase from the showroom, my lord. Showroom. So 3 units, showroom, manufacturing unit and godown. Now suddenly in this case, almost all the cases, my lord. Suddenly municipal authority along with some forest official, my lord, they came and sealed the, in this case, manufacturing unit. No notice, nothing at all in this case. You also kindly see page 13 is my trade license.
No notice has been
No,
issued.
nothing
Yes, Mr. Gogol.
in this case.
This whole industry is covered by regulation, my lord. We established those industries, they have to get licenses from us because they are using timber. And because those timber.
Now, what
my lord,
about an opportunity?
opportunity issue doesn't come because, my lord, before that also they have been, I have instructions because from 2025 or 24, we have been issuing a notice to come and register with us.
Where is the notice?
But
My lord, we don't have those now, my lord, but I took a verbal instructions, so notices are there.
You get the notices.
Yes.
We'll have this on Monday. Monday or Tuesday.
My lord.
But if you have not given notice, you cannot take an abrupt action. You can take action in accordance with law, but you have to give them an opportunity.
My lord, in fact, what has happened, they are using timber, which is a forest produce.
Those who have
Now,
understood. Now, something, if it is not authorized by law and you notice it, then you at least give an opportunity. What is your case?
My lord.
If you have done that, then our views may be different. If you have not done that, our views. We'll have it on Tuesday, Mr. Chaudhary.
Tuesday. Then all
You
the
are-
cases, man.
Huh?
All
All the cases, all the
In
cases.
fact, my lords, the item
Monday would have taken, but Monday he may not have adequate time. Today being
7, 8 are almost similar, my lord. These are all
Ke to khagas hai.
6, no,
Done.
6,
Now 4, 5, 6, 7.
6, 7, my lord.
Same.
okay.
3, 4, 3, 4,
Hard three, like a hard three HRA Chaudhary, Land Senate Council, as well as who's on the other case from yeah, as well as Sri A.M. Ahmed for the petitioners who are aggrieved by, amongst others,
Sealing of the.
and amongst others, an action of sealing of showroom / manufacturing unit / godown, which are connected with timber business.
Yes,
Full stop. It is contended that the petitioners have trade license
yes. ma'am.
and no notice,
GST also he paid. up to
trade
the
license
GST.
and have and are following all the requirements of law. Full stop. It is specific. It is the specific contention that such sealing has been done. SEA, sealing has been done without any prior notice. Para. Sri D. Gogoi, Learned Standing Council, Forest Department, has however submitted that as per all instructions, notices, prior notices were issued. where issued from time to time, directing the units to register themselves, which has not been done. Para? Sri Gogoi is directed to obtain specific instructions in this regard. Para? List these matters for motion on Tuesday.
21st.
May I request my lord, the
Extra
document
copy.
furnished, my lord,
Yes,
for
yes, yes.
Soft
Two.
copies, my lord. Soft copies. Extra copies, takes time.
Soft copies.
Like, if
All
I
right,
use that,
all right,
my lord,
all
soft copies.
My lord,
Okay, that will be easier for them.
yes, they will give.
Okay. To facilitate Sri Gogoi, the Learned Standing Council, to obtain the instructions, let extra copies, including soft copies, including extra copies, including in the soft format, be served upon Sri Gogoi during the course of the day.
Right.
This will be in item numbers
3, 4,
3,
6,
4, 5, 6.
5
Oh,
also.
5 and
6,
okay. 3, 4,
6 and 7.
6 and 7.
5 also, Mr.
No, 5
No.
was different.
5 is different.
5 Karbi Anglong.
Oh, 5 is different, yes. Wait a minute, yes, Mr.
May I please?
Laskar?
My lordship, I'm doing business on my Miyadi Patta land, my lordship. It is non-timber forest produce, my lordship. And it has been sealed, my lordship, and we have all the permissions. from the-
Timber, same case.
No, my lord. It's a kind of herbal medicinal product, my lordship, forest produce.
Hardware medicinal product.
Yes, my lordship. And it is a perishable product, my lordship. Perishable items, my lord.
What is the what is the net result? What do you do with this?
My lordship, we transport it to the medicinal company.
Then
and
what
they-
kind of medicine?
My lordship, herbal medicinal kuturi. What is they call it katuri? It's a wild turmeric, my lordship.
Turmeric.
Wild turmeric.
It's not
And
a
we have all the permission
it is
from.
not a forest produce.
No, but they have given
My lord,
permission, my
it is
lordship.
different. My lord, he has established his processing unit in a reserve forest.
My lord, they are saying that, but we have Patta land, we have annexed the Jamabandi, my lordship. The Jamabandi was on page 19, my lordship. Page 19 is the Jamabandi of the land, my lordship. And my lordship, if it turns out to be a forest land, my lordship, but the sealing of the perishable product, my lordship, and I have been doing business with requisite permission from the department, my lordship. All
But,
the permission
on
I
the
have.
first date, how do you expect a release? It has been confiscated. You take the instructions. If it's Miyadi Patta land, how do you do it?
My lord, Mehadi Patta land, page 19, I have an.
We issue a short notice.
Yes, my lord.
Short notice, 2 weeks notice. Okay.
My lord,
We fix a
perishable
date.
product land, my lordship.
Huh?
Perishable product land. It's a perishable
Turmeric will
product.
not perish within 2 weeks.
My lordship.
We'll give it 2 weeks. Unless in the name of turmeric, you are having something.
No,
else.
no, my lordship. No, my lordship. All the requisite permission I have annexed, all the permission from the department, my lordship.
Okay. Heard Sri S.B. Laskar, Learned Counsel, for the petitioner who is aggrieved by a confiscation proceeding initiated under section 49(4).
Yes, sir.
49(4) of the Assam Forest Regulation, 1891, by issuance of a show cause notice dated 2/7/2026. Full stop. While the department contends that the depot is situated within the Raikkoshini proposed reserve forest, the petitioner contends that the depot is over Miyadi Patta land. Para. The learned para, let notice be issued, returnable on no, Tara got Loma. The learned counsel for the petitioner has submitted that the goods involved is 38 quintals of katuri, which is a kind of wild turmeric.
Yes, my lord.
Para. Let notice be issued, returnable on the 3rd of August 2026. Sri D. Gogoi, Learned Standing Counsel, Forest Department, access of 1 to 4. 1, 2, 3, 4.
1 to 3.
Whereas Sri G. Bukalia, Learned State Council for 5 and 6, extra copies. Para. Sri Sarkar, the Learned Council, prays for an interim order by contending. No. Sri Sarkar, the Learned Council, for the petitioner by contending that the goods in question are perishable in nature, has prayed for an interim order. Para. The interim prayer would be considered after receipt of the instructions by the Learned Standing Council on the next returnable date.
My lord, any date will be fixed, my lord.
We have fixed the date.
Okay,
Third.
my lord. Yes, sir.
Extra copies. Upor extra copies likhiba.
Problem.
Highly obliged, my
Petitioner
lord.
extra copies nokole likhiba. Yes.
May it please your lordship. Non-payment of contractual dues.
Non-payment of contractual bill. Liability.
Liability, my lord, they in fact forwarded my bills. Completion certificate was issued by them, a total of 6,70,000.
Now, where is the liability?
My lord, 6 lakhs.
Where is the acknowledgement?
My lord, your lordship will kindly see at page 25.
25 is the completion certificate.
Yes, there, my lord, the up-to-date bill value, your lordship will kindly see at clause number 13.
We have seen all this. Where is
Well,
the liability
well,
of acknowledgement by the chief engineer?
My lord, chief engineer's liability, we preferred representation at page 30 for issuing, but that has not also been issued. So that
Then
is
you go to the civil court.
my lord, your lordship will.
We do not have any other option. We cannot say anything above the full court,
My lord,
full bench.
my lord, Tamsher, of course, my lord will come, but one submission, my lord, if your lordship allows me to make. Apart from the completion certificate, my lord, there are this demand was forwarded by the executive engineer at page 27.
27.
Yes, this is the consolidated bill. This bill actually has been forwarded by the executive engineer, countersigned by assistant executive engineer and
That will
subdivisional.
not be enough.
I understand, my lord, the
Will not be enough.
difficulty is there, but unless, my lord, they.
And secondly, the works were completed in the year 2021.
Completion certificate was in the month of December 2022, my lord.
22, and we are in 2026,
My
July.
lord, thereafter in 2023, my lord, I renewed my prayer, and then, my lord,
You approach the civil court.
my lord.
Third, Sri D. Chakraborty, Learned Counsel for the petitioner, who by means of this application has paid for a direction for release of contractual bills amounting to rupees 6,79,173 for works done it works done in connection with the scheme within inverted comma restoration of Purandarpur water supply scheme. Full stop. The Learned Council has submitted that the work was duly completed, and in this connection, a completion certificate was issued, which was duly signed by the executive engineer, PHE, and the assistant executive engineer. He has also relied upon a proposal forwarded by the executive engineer for demanding funds, which includes the scheme in question. Full stop. Para. On the other hand, Sri D. Gogoi, the Understanding Council PHE, has submitted that the scope of interference by a red court in matters for release of contractual dues is limited and has been and the principles, and the same is governed by the principles laid down by the Honorable Full Bench in the case of Tamsir Ali versus so and so. Para. In the aforesaid case of Tamsir Ali, the Supra, the Honorable Full Bench has laid down the following conditions. In the instant case, though there are completion certificates, there is no acknowledgement of liability by the chief engineer or head of the department, which is a mandatory requirement laid down by the Honorable Full Bench to exercise jurisdiction by a writ court para. In view of the above, this writ petition is dismissed. Full stop. Dismissal of the writ petition shall not, however, be a bar for the petitioner to approach the appropriate civil court for redressal of his grievance. Full stop. The civil court, if such approach is made, this learned civil court would adjudicate the matter in accordance with law and without being influenced by the decision of this court.
Grateful, obliged.
It's a blacklisting of farm as well as department of the product, my lord. Which
Without
department? Mr. Ghosh,
Notice may go, Lord.
when was the blacklisting done?
My lord, it was done in 11th, my lord, November
November 25. You should have come immediately.
My lord, that is correct.
How many, what is the tenure?
Tenure is about 3 years.
3 years?
Yes.
Okay. Part 3G and Sahel are learned senior counsel assisted by, madam, your name? Huh?
Timor.
Timur. Timur. For the petitioner. First of the grievance of the petitioner is against an order,
Well, against 3 orders, my lord.
against certain orders by which this petitioner has been blacklisted
As well as.
and debarred from participating in any tender or procurement process for a period of 3 years. What are your main grounds, Mr. Sawali?
Main ground, my lord, this main contract is not cancelled, my lord. That is the condition precedent.
It is submitted that amongst others, the blacklisting, the contract in connection of which the blacklisting has been done has not been cancelled, and therefore there cannot be any grounds for blacklisting, for passing the impugned order. Let notice be issued. Returnable on Mr. Bora.
After 4 weeks.
We have a date, Mr. Sayola.
Yes.
On 14th of August, 14th of August, Sri BP Bora, learned DP Bora, learned Standing Council Health Department, accepts notice on behalf of.
All that.
All that.
What about 4?
Yes.
Procurement QC?
Yep.
You can. All
All
the respondents. Extra copies be served upon him during the course of the day.
Monday, my lord, by Monday.
But within 2 working days.
Obliged.
DP, huh? We said? Dipamkar. Mr. Gogol?
In this case, my instruction was all followed.
This is we ask for the timing.
What is the matter?
Regarding my lord, while my extension pair for.
Yes. Where is Mr. Sharma?
Under consideration.
Okay, let him come.
Gotcha.
After
Give
a
him.
while. Mr. Bonkim Bora, yes.
May please, your lordship.
Caveat. Who's for caveat?
Yes, Lordship, I am.
Caveat by the AFC.
Yes.
Okay. Part 3 J.K. Goswami, learned counsel for the caveat, which has been lodged in connection with
No. Notice issued.
a notice dated 13/7/2026 issued by the caveat. Full stop. The caveat would be heard in the event this court proposes to pass any interim order. Caveat stands discharged. Yes, Mr. Bora.
May it please, your lordship. Lordship, the petitioner took a loan of 70 lakhs from the AFC. The project cost was 1,44 lakhs.
Yes.
The petitioner took a loan of 70 lakhs, 74 lakhs was from his own contribution. He opened a beverage industry of packaged drinking water. He did the land development work, he bought the machineries, and he turned it into a profit-making industry. Now, in MSME, the first jolt was
You're an MSME.
yes, the first jolt came with COVID, like all industries. The second was I was not given that, now also not given the 33% MSME subsidy. Thereupon also, I regularly paid the loans. It was for a period of 7 years, from 18 October 2018 to September 2025. For 84 months at the rate of 119,657. I have cleared the principal of 70 lakhs and till now have paid, as per my instruction, 90 lakhs something. I have to pay 1 crore 45 lakhs. Now in the month of January, the Jorhat branch office called me that till March you pay 15 lakhs and I will not take any steps. I made effort to pay 15 lakhs. I paid around 14 lakhs something. Thereupon also, now on 13/7, a impugn notice have been issued for takeover under section 29 and transfer. Lordship will note that. Takeover and transfer of my industrial unit.
29 of the AFC Act.
AFC Act. Lordship, I will place that if required. Lordship, now on 14/7, before I divulge into the legal issue of it, on 14/7, I made a representation to the chairman AFC, saying that it was the AFC who have, by whose assistance, I have become from an unemployed youth to a small scale businessman, and I'll pay the entire loan. Just give me a time of 6 months. I have not get the subsidy. I was halted by the COVID, but I'll pay within 6 months. If required, I will give a upfront amount and a monthly installments. Within 6 months, I will clear it. My assets are 5 times more with the AFC, are 5 times more than the outstanding payment. Therefore, Lordship, before I divulge into the legal issues of it, I make a sincere prayer that I will, if AFC gives me 6 months time.
Mr. Goswami, what do you say?
Yes, sir.
Without entering into the merits of the dispute, he has made an offer. 6 months' time, he will clear everything.
And now also I will make an upfront.
And obviously, we have not said anything. We have not expressed anything. We have not even said anything about upfront
Yes,
payment.
we have the provision, Lordship.
Yes.
We have the provision loan recovery policy, and it is clause 7, Lordship.
No, not on the legal issues. He's asking for time. Yes, how much amount are you willing to pay?
Yes.
Lordship, as for page 42 is my account statement. In the account statement, the branch itself has given a note. As per me, it's 48 lakhs. As per them, it's 53 lakhs.
Now, how much as on today? How much amount?
As on today, Lordship, I have already taken instruction. 8 to 10 lakhs right away. Within 3 days, I can pay, and monthly 5 lakhs monthly, Lordship. I'll clear it by 6 months.
Lordship, may submit, Lordship. We have a policy, Lordship. Policy is that if we take over the industry, Lordship, take over his institution, Lordship, then also we have the policy. If he will deposit 50% of the total amount, we'll hand over to him, Lordship. That is our policy. It is policy clause 7.
That is okay, but he's been running since 2018. He's an MSME. Give him a chance.
Yes,
We'll direct him to make.
We have given him from 21, Lordship, 21 to 2025, Lordship. Lots of demand notice were issued. More particular, Lordship, some checks were deposited by him, which was dishonored, Lordship. That is the conduct of the petitioner is not.
Now it would be a court monitored conduct.
Yes, Lordship. Yes, I understand.
Earlier, his check got dishonored. Now, if his conduct is against the equitable jurisdiction, we'll dismiss his matter.
Yes.
We may go to the rule 5, rule 7 of our.
Don't take over. If you take over everything, will be.
No, Lordship. If and when he will encase 50% of the total, Lordship.
How much is 50%?
Lordship, it is 48, 50 lakhs, Lordship, 25 lakhs. 25 lakhs something.
Okay. Well, let us balance the equities. Let us do something. Third, Sri BP Bora, Learned Counsel for the petitioner. Also heard Sri JK Goswami, Learned Counsel for the AFC which has lodged a caveat. AFC, within bracket, respond number
Here, Lordship, phone number
2,
3, 4,
2, 3, 4.
yes.
Within bracket, respond number 2, 3.
2, 3, 4, and 5, Lordship.
2, 3, 4, and 5 also.
Yes, 5.
5. Para. As per the facts projected, comma, the petitioner is an MSME registered unit under the Ministry of Micro, Small and Medium Enterprises, having an Udyam registration. Full stop. The petitioner, why 2 petitioner?
Also, one is the industry, one is, he is the owner.
Okay, petitioners boli kama, huh? The petitioners had availed a loan from the AFC under a scheme for setting up of packaged drinking water. Full stop. The financial assistance was of 70 lakhs and the project was for an amount of rupees 1.44 crore.
Correct.
Full stop. The petitioner claims to have started the industry and was running the business, which however was seriously affected by the pandemic of COVID-19. Full stop. It has been projected that the industry had started in the year 2018.
2018.
Full stop. Be that as it may, comma, the present notice pertains to a default on the part of the petitioner to repay the loan which is initiated by the notice dated
45. 13/7/2026.
13/7/2026. Full stop. Para. The learned counsel for the petitioner has submitted that without going into the legalities, which includes the non-release of 33% subsidy
Yes.
for an MSME, comma, his client is willing to make, his client had made representation on 17/7/2026.
14/7. Next day.
14/7.
Next day. Page 46.
14/7/2026 to the chairman seeking 6 months' time to liquidate the amount. And he is also willing to make an upfront payment. Para. Sri Goswami, the learned counsel for the contesting respondents, has however submitted that numerous opportunities were granted to the petitioner to make good the loan which they had failed. Full stop. He has also submitted that the rules governing the field also envisages that the proposal can be considered provided 50% of the total outstanding is paid as upfront. And as on now, the liability is about 50 lakhs. 50 lakhs.
Total liability.
42, page 42. Lordship.
Page 42.
Is about 50 lakhs.
Lordship.
Para.
Above 50 Lordship.
We said about.
No,
Above 50 lakhs. Para. Responding to the same, comma, Sri Bora, the learned counsel, has submitted that his client is willing to deposit an amount of rupees 10 lakh within a period of 3 days. Full stop. Para. Let notice be issued, returnable on
3 days. 4 days.
We'll have it on 10th of August. 10th of August. Three Industries Commerce Department, Priyam Chetia for 1 and 6. As noted above, Sri J.K. Goswami, the learned counsel, has accepted notice, has appeared on behalf of respondents 2, 3, 4 and 5 on the strength of the caveat. Let extra copies be served. Para. Heard the learned counsel on the interim prayer. Para. On the basis of the submissions made, which are recorded above, this court is of the view that equities would be balanced if the petitioner, if the impugned action is put on hold, provided the petitioner deposits an amount of rupees 15 lakhs within a period of 2 weeks from today. Full stop. The interim order would, however, be reconsidered on the returnable date. Full stop. During dependency of this case, the petitioner would make further endeavor to make payments towards liquidation of the loan. Full stop. It is made clear that no action for taking over the unit be taken till the next returnable date.
No, 50, can it be 12 lakhs, Lordship?
Not 12.
My instruction is 8 to 10 lakhs, therefore, Lordship.
He stated categorically in his.
I'll
It is this 50 lakhs 89,565. He himself stated in page 42.
No, that is bank statement.
Yes,
50 is the total, 15 you have to pay. Yes. We have given you 2 weeks time. We said 3 days for 8 lakhs.
10 lakhs. 3 days for 10 lakhs.
10 lakhs. We said 2 weeks for 15 lakhs.
15 lakhs.
Deeply obliged.
3 days for 10 lakhs.
No, within 2 weeks, he'll pay 15 lakhs.
Deeply obliged.
15 lakhs.
Yes.
Lordship, also his submission should be may be recorded, Lordship.
Yeah.
Regarding, he stated that within 6 months he will complete the.
That we have already stated
Yes, we have
in the
already.
representation. And if he fails to make the deposit, we'll vacate the interim order. Okay. You make endeavors, Mr. Bora, save your industry. And don't spend in any other activities.
No, Lordship.
Once you get some money, you spend in any other activities.
Deeply obliged.
5th of August.
Yes, we have set one Kulu. 10th of August.
10th of August.
Deeply obliged. 15 working days. 15
Huh?
days.
2 weeks we have said.
2 weeks.
2 weeks.
Which will let us give the date. 2 weeks, Aparna. 2 weeks, which would expire on today's 17th, which would expire on the last date being 3rd of August. You get more than 15 days. 1, 2, the 31st. First is Saturday, Sunday. We have given you extra 3rd of August.
May I please observe? My lord, in this case, my lord, the respondent number 4 issued an auction notice, my lord.
Respondent number
4, my lord.
4.
Page 13, my lord.
Who is 4?
4, my lord, General Manager, District
How?
Industries and Commerce. District, page 13, my lord.
An auction notice was issued.
Issued.
Thereafter,
Thereafter, my lord, as per auction notice, my lord, all the petitioners submitted earnest money, my lord, deposited earnest money by way of Chalan, Treasury Chalan, my lord. But they became unsuccessful, my lord, subsequently.
Hmm.
Then they approached the respondent number 4 to return their earnest money, my lord. And in response of their approach, my lord, the respondent number 4, my lord, made a communication with the treasury officer, my lord, to return the earnest money. Your lordship will find page 20, my lord.
yes, then
Then, my lord, treasury officer, my lord. This is the page 23, my lord. He says, my lord, with reference to a subject, I would like to inform you that there is no provision for refund of the amount deposited under so and so head, my lord. That is why, my lord, petitioner is before this.
yes, who will take instructions? Earnest money is one entitled to be refunded.
Yes. This is the piece 17.
17. Yes.
Piece 17 matter take up 5.
17.
17.
Yes.
The last 2 sentences, we received a letter stating that
Non-refundable head.
non-refundable head, and there was no provision of refund from that head. Next page, madam.
Okay.
Under such circumstances, considering the inconvenience situation discussed, you plan as the refund of the EMI has been delayed due to procedural changes only, madam. After the payment has been done, madam, it may be refunded to him because it was submitted in a non-refundable format.
No, say that was, see, there would be 2 aspects. Whether earnest money for an unsuccessful bidder would be refunded, number 1. If that is a refundable amount, then your mistake in depositing the amount in a non-refundable head should not cause any prejudice to them.
Yes, sir.
So the first question is whether it's a refundable amount. If it's a refundable amount for your procedural default, they should not suffer.
They are taking steps, madam. This impact. So sometimes.
Now, if you deposit in a non-refundable head by the treasury officer will straight away say we cannot refund. But why have you deposited? First, your question, which you have to answer, is whether it's a refundable amount. Where is the auction notice?
Auction notice, my lord. Page 13, my lord.
1-3.
1-3, my lord.
What does it say regarding the earnest money?
Nothing says, my lord. It is no specific statement in this regard, my lord.
So how do you know that it's a refundable amount?
No, my lord, the treasury, respondent number 4, my lord, he himself stated that it is refundable.
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 Okay, we issue a notice, short notice. You give instructions, sort it out, okay? Heard 3 A.H.M.R. Chaudhary, Learned Counsel for the petitioners. Footstep as per the facts projected, comma. In response to an auction notice dated 14/12/2023, the petitioners had submitted their bids and were found to be unsuccessful. Full stop. As a condition, comma, the petitioners had also deposited earnest money, and on being declared unsuccessful, had demanded the earnest money. Full stop. The earnest money was said to be deposited by the respondent number 4 in the treasury office, and accordingly, instructions were issued for such refund. Full stop. The treasury officer had, however, informed the petitioners that it was deposited in a non-refundable head, and therefore such refund was not possible. Full stop. Para. It is the specific contention of Sri Chaudhary, the learned counsel for the petitioner, that earnest money of an unsuccessful bidder is liable to be refunded. Para. Let notice be issued returnable on when 12th of August 2026. Finance Department. Finance, Sri H. Barua, for Finance, for representing Finance Department for 1. District Commissioner M. Chetia 1. I think Treasury Officer also Barua, 1 and 3. 2 and 4 by M. Chetia, State Council. Extra copies within 2 working days. Yes. Have the instructions and give. You also give necessary instructions to sort out the matter. Pendency of this repetition shall not be a bar for making provision for refund of the amount to the petitioners if they are legally entitled to.
May I please, Your Lordship? By order dated 15/6/2026, Annexure 3, page 15, IWT has issued this letter settling temporary settlement in favor of me, the petitioner, for a period of 46 days with effect from 16/6/2026 to 31/7/2026.
Settlement of what?
Of ferry service.
Ferry service.
Of past 5 Nong Bajbari Bazar via Salavila Bandara.
Which district?
In the district of Bongaigaon.
Bongaigaon. Yes, thereafter.
The bid amount was 30,100.
Yes.
The amount has been deposited. Acknowledgement has been received.
That was for 46 days.
46 days.
Thereafter.
Then, Your Lordship, page 19, Annexure 6. IWT issued another settlement order, temporary settlement order against the
This 15/6, it was settled with you?
Yes.
Okay. Thereafter?
Therefore, on recently order 15/7/2026.
Yes.
Another settlement of temporary settlement.
26.
26.
Okay.
Another temporary settlement,
After 3 years,
Lordship.
after 3 years,
No, Lordship, after 1 month,
26 na 23 then.
26,
15/6/2026.
You said 23, 15, 6, 26.
26,
Okay. Okay, now 7, 15, 7, 26 again.
26.
Yes.
Another temporary settlement order has been issued against the ferry service which has been operating by me, Lordship, for a period of 15 days with effect from 16/7/2026 to 31st/7/2026 without cancelling the earlier order. Lordship, still I am operating.
Lordship, may kindly have a look.
Your tenure was from 16/6/26 to
31st/7/26.
at least till 31st of
Lordship.
July, you are entitled to run. That is your case.
Yes, Lordship.
And during the pendency of your settlement, they have issued another settlement for 15 days.
15 days.
Lordship, page 15 again, madam.
1-5.
Yes, page 15, the order of executive engineer, Lordship. Designation, Lordship, may kindly note, executive engineer, IWP Dubai is may I read, madam? As per the short tender notice number solicitations, such, the following tender participant against the mentioned ferry service has submitted all the necessary documents as per the notice inviting tender and has been qualified as successful bidders, and hence they are allowed to operate with effect from 16/6/26 to 31/7/2026. They are instructed to deposit such and such. Then the last paragraph. The arrangement is purely temporary. If any instruction, direction is received from the higher authority regarding the operation of the above mentioned ferry services through the tendering process of the period 26/29, the temporary arrangement shall stand, withdraw, cancel with immediate effect, and further action shall be taken in accordance with the such instruction. Lords may kindly note that paragraph. Then my lord may turn to page 19.
19.
19. It's a letter dated office order dated 15/7/2016. The lordship may read. In pursuance of the approval conveyed by DIWT order number such and such dated 4/7/2026, the following tender participants have been selected as the highest qualified bidder for the respective ferry services for the period 2026 to 2029 for 3 years, are hereby permitted to operate the ferry service as per their quoted amount. The operation shall be effective from 16/7/2026 to 31/7/2026. Hence, all our requested deposit such and such are before trusted. Serial number 7, the petitioner who is petitioner is running, he has claimed. Number 5, Basamari such and such. One Mohiruddin was selected as the highest bidder. Then my lord may kindly have a look the tender committee decision which was taken on 19/6/2026, page 25 relevant. Page 25. The petitioner did not challenge this tender committee decision yet. 25.
No, I have challenged. I have challenged.
No challenge.
25. 25. Just a minute.
25. Serial number 17, my lord. Lordship got it?
Yes.
5 number Basabari Bazar via Salabila Bandara ferry service. As per the competitive statement, it was found that 3 bidders have participated in the tendering process for settlement of 5 number Basabari Bazar via Sasan ferry service for the period 2026 to 2029 for 3 years tendering process, madam. All the bidders have deposited their required amount of earnest money along with the tender. The estimated value of the ferry services such per year. The name of the bidders and documents submitted are mentioned below. Abdul Samad, all documents submitted as per NIT. Mohiruddin, all documents submitted as per NIT. Mokshad Ali Mandal, this is a petitioner here, my lord. Failed to submit both registration certificate. All other documents submitted as per NIT. So he is technically default bidder in the tendering process, my lord. So we have decided the earlier order which was issued by the executive engineer, it is mentioned that it is very temporary. If any order received from the higher authority, then it will be automatically cancelled. It was mentioned in the last paragraph, 15/7/6 annexure, page
15.
Page 15 order, my lord. It was mentioned, and subsequently the tender committee has taken the decision. Technical bid has opened, and the petitioner emerged as the default bidder, my lord. He did not submit the document as per NIT. So we have decided to run the ferry service for temporary 15 years. It will take some time to issue the final order. So we have decided, the tender committee has decided, government has decided to run the ferry service with the highest bidder, who become the highest bidder, who has submitted all the documents. So we have directed the executive engineer to hand over the ferry service to the one Mohiruddin. He appears to be the highest valid bidder. So this is the case. And he did not challenge the tender committee meeting dated 19/6/2026. So Lordship.
May I please, Your Lordship? Lordship, I have already challenged these minutes,
Is it? Let us
Lordship.
see.
which is WPC 3559/2026.
In separately.
Separately.
Here he only challenged the 15th.
Oh, it says already put to challenge.
Already challenged, and it is fixed on 24th.
Notice has been issued there.
Notice has been issued. Lordship, if final settlement has been issued, I have no problem. Till I am operating, the order is still in force until 31st July. And this, Lordship,
This order
page,
is
page 19, Your Lordship, only 15 days. They have settled this ferry service only for 15 days.
Madam, you allow it to run till the tenure.
Lordship.
I'll get instruction, madam, fix the matter on Monday. Would
No,
you instruction, because Lordship,
and-
this order is on 15th.
And maintain status quo till Monday.
Lordship.
You have the instructions on maintain status quo.
Lordship.
See, the earlier process was by a tender. It was not that he was simply selected from nowhere. People participated. He was given only for a period from 16/6 to 31/7. It was a temporary arrangement. You are right in contending. But it is not replaced by a permanent arrangement. It is replaced by another temporary arrangement.
Temporary arrangement.
Temporary, so which was is a emergency highest bidder.
You give it to the highest bidder for final selection. You have not done.
It will take some time.
No,
That's why
till such time is over, let him run at least till the period of 31/7/2026.
Lordship.
That was not done by pick and choose. That was also done by tender. That is what
Understand, my lord. But then last
You
point
may-
is very clear, my lord.
you take, if you want, you can,
If
we'll
I
allow
take
it, we will have you to allow the instructions on Monday or,
Yes.
okay, or we can issue a short notice, whatever.
Notice because private respondent.
Status quo is my payment.
Okay, heard. What is your name?
P. Roman.
P. Rahman, learned counsel for the petitioner. Full stop. As per the facts projected, comma, pursuant to a short tender notice dated 9/6/2026, comma, the petitioner was granted temporary settlement to run the 5 NO Basabari Bazar via Salabila Bhandara ferry for the period 16/6/2026 to 31/7/2026. It is contended that the bid amount of rupees 30,100 was deposited by the petitioner. Full stop. In the meantime, comma, a process was held for settling the settling the ferry on permanent basis. Full stop. However, wide the impugned order dated 15/7/2026, the settlement has been given to the private respond number 4 for a period of 15 days from 16/7/2026. Full stop. Para Sri Raman, the learned counsel, has submitted that the petitioner settlement, though temporary, was stipulated to be up till 31/7/2026 and is not replaced by any permanent settlement. Full stop. Para. On the other hand, comma, Ms. M.D. Bora, the learned standing counsel, IWT, has submitted that the initial order of settlement dated 15/6/2026 had clearly stipulated that the arrangement was purely temporary and could be withdrawn or cancelled on instructions of higher authorities. Full stop. She has also submitted that the settlement process for the ferry in question was taken up by the tender committee in its meeting dated 19/6/2026, in which the respondent number 4 against serial number 17, correct,
Yes, madam.
Lordship.
was found to be the highest bidder, and the petitioner was found to be failing in the aspect of having both registration certificate. Full stop. Para. Issue notice returnable on, we give a short notice.
Monday,
Not Monday, returnable on today is returnable on next Friday, on 24th. But private will not be, they'll not be served. Oh, you serve Dusty on 24th, huh? 24, no, 27, 27. Oh, next date, 37 or 31 to Khotam. 24th, 24th. Miss Bora, the Learned Standing Council accept notice on behalf of respondent numbers of the official respondent numbers 1, 2, and 3, that extra copies, 4 by registered post, first speed posted daily. Full stop. Additionally, the said respondent is required to be served Dusty by the petitioner, which is to be routed through the registry of this court, and the next date fixed, i.e. 24/7/2026, be clearly reflected in the notice accompanying the notice. Full stop. Para. Sri Rahman, the Learned Council prays for an interim order. Para. Considering the facts and circumstances, and also the point that a temporary arrangement has been sought to be replaced by another temporary arrangement, comma, the impugned order dated 15/7/2026 pertaining to the ferry in question shall remain suspended. Full stop. The aforesaid interim order would, however, be reconsidered on the returnable date on obtaining of specific instructions by the Learned Standing Council.
May kindly observe, pendency of the writ petition may not be a bar for the final settlement of the ferry.
Obviously.
Lordship may kindly observe, otherwise they will file representation.
It is, however, made clear that since the present, since the subject matter of this writ petition is only with regard to the temporary settlement, comma, there would be no bar for making final settlement in accordance with law after expiry of the period which was given to the petitioner, expiring on 31/7/2026.
So deeply of that matter.
Hello.
অলপ লাইনটো ঠিক কৰি দিম, দুবাৰ এক্সপায়াৰী আহিছে ইয়াতে।
Wait, please, Your Lordship. In this case, I have filed one IA in the contempt petition informing the court about the death of respondent number 2, Lordship.
R2.
Yes, Lordship. They have filed the contempt petition, Lordship.
I think in the meantime, they got NOC from the Gauhati side, as mentioned under section 107 of Assam Panchayat.
Is there anything remaining?
Lordship, they are the petitioners.
Some instruction.
Only it is my
You are
duty
for the
to-
respondent.
Yes, Lordship, I am for the respondent.
Okay.
Then they can
R-
withdraw their contempt
Ms.
petition.
R.
Lordship.
Chaudhary, Learned Senior Counsel, who has filed this application under the spirit of Order 22,
Yes, Lordship. Rule
10A.
10A.
Rule 10A, informing the read with section 151 of the Code of Civil Procedure 1908, informing the fact of the deaths of the respondent number 2. Full stop. Also heard Sri A.J. Hazarika, Learned Counsel for the opposite party petitioner. Full stop. Let instructions be obtained by Sri Hazarika and the matter be listed. Instructions be obtained by Sri Hazarika, full stop. At this stage, no, it has been complied with.
It can be disposed of, Lordship. It is my duty to inform the court, Lordship, so I have accordingly. IA can be disposed
No,
of.
IA is disposed of.
Yes, Lordship. He died on 24/5/2026 after receiving notice.
What about the contempt? Can it be
Contempt,
disposed of?
Lordship, no, contempt, they are the petitioners, Lordship.
Well, has it been complied with? Transferred ki karo.
Already another contempt petition was dismissed, Lordship.
Hazarika. Stop. IA stands disposed of. In the main contempt, you write. An order has been passed today in IA number so and so. Instituted IA number so and so. Observing, recording the death of the respondent number 2.
Lordship.
Full stop. Sri Hazarika, the learned counsel for the petitioner, prays for and is granted 2 weeks' time to obtain instructions. List of the 2 weeks.
Lordship. Obliged.
Appear for the respondent of the law, 7 your lordship, I prayed for an adjournment in the morning. And my effective.
Item number?
12 your lordship, I made a prayer for adjournment.
Yes,
My lord, issue is, my lord, whether, my lord, the liability of one legal entity can be adjusted by my lord, another legal entity, my lord. And that question was answered, in fact, my lord, and they are not disbursing my lord subsidy amount, your lordship.
Mr. Gautam, here for whom?
For R6 and 7.
Who are 6 and 7?
Net fee of general manager and.
See, they had prepared for time. We are not inclined to grant time because they had entered appearance long time back.
21.
You file your affidavit within a week.
Lordship next Friday.
Well, that's the final.
Lordship.
Okay. Heard. Sri A. Goel, learned counsel for the petitioners. Para. Sri N. Gautam, learned counsel for the respondent number 6 and 7, has prayed for time to file affidavit in opposition. Para. Considering that this matter is pending since the year 2020 and the respondent number 6 and 7 had entered appearance long time back, and were earlier granted time to file affidavit in opposition, this court grants a final opportunity to the said respondents to file affidavit in opposition. Para. List on 27th of, we grant you 2 more extra days, 27th of July to file the affidavit in opposition.
Lordship, some matter can be on 24 to lordship, 27 to 29 lordship.
You file the affidavit, let us see, we'll grant you time.
Lordship.
We only then 24th if you can, 24th.
And union may be directed to obtain instruction, my lord.
By the next date, CGC.
CGC.
Who's CGC?
Respondent number 2, 3, 4, 5.
Mr. Bhattacharya, you are CGC. Who's CGC? Anyone CGC? Mr. K. Gogoi? Sri K. Gogoi, CGC, is also directed to have the instructions by the next day. Please inform him.
Deeply.
Lordship, my senior is next on another court. Kindly pass about the matter for the time being.
Item number?
14.
What is the matter, Mr. Roy?
Lord, they wanted time to obtain instruction whether they have extended the bank guarantee because the bank.
Yes, we remember.
Yes, sir. Lord. So only.
Have you extended?
Bank guarantee, have you extended?
Not extended, or no instructions?
No instruction, Lordship.
You should take the instruction. Won't you discuss matters in the previous evening? If a matter is there in the court, don't you discuss the matter? What is the outcome of the discussion? Bank guarantee extended or not? You should have the minimum facts. Okay, after a while. Mr. Sharma?
May I please watch. My lord, matter is my lord, Bakijay proceeding, we are agreed by the Bakijay proceeding.
Affidavit filed by R3.
Yes, my lord, they have filed.
Would you like to file your response?
Well, I have no contact with after getting interim order, my lord.
Then they vacate
What
the interim order
what
and
to
dismiss
do?
the writ petition.
Problem is this one.
23 matter.
Earlier this morning,
Then we take up this matter for
what happens, my lord? Actually, due to delay in granting the environmental clearance, that is the problem.
Let us then take it for disposal and decide in accordance with law. Yes, what is your case?
My lord, initially, my lord, the petitioner was a settlement holder. And my lord, by Annexure 35, work order has been
Settlement
issued.
holder of what? Of a query?
Settlement, yes, my lord, sand and gravel mining contract area. Name is, my lord, Bhimpara Subansiri Riverbed, Bhimpara Sand and Gravel Mining Contract Area. Work order is at page 31, my lord.
Dated?
Dated, my lord, 25/2014.
14?
14. Hello.
Okay.
14 to 20.
How many years? How many years?
For 7 years. My lord.
7 years.
I'm sorry, my lord. Work order is at my lord 25/9/2014. So
25/9, not 25.
25/9, my lord.
25/9.
35.
25/9.
Work
Okay.
order has been issued, and Mohol period will be expired on 27/2021 for 7 years, my lord.
Thereafter?
Thereafter, my lord, they have entered into agreement, and then, my lord, environmental clearance was obtained for a period of 5 years, my lord. Initial environmental clearance was for a period of 5 years, my lord.
When was
That is
that?
Annexure 1, my lord. That is Annexure 1, 19.5 at page 31. That is for period of 5 years, my lord. That is means 25/2014 to.
This environmental clearance is by which annexure?
Annexure 1, my lord.
Page?
Page, my lord, 31.
31. But your settlement period is also from 31 page.
Work order is, my lord. Work order is, my lord, Annexure 2. And, my lord, environmental
Page,
clearance.
work order, page?
My lord.
Page of the work order?
Work order is, by my lord, 35.
That is 25/9/2014.
25/9/2014.
And an environmental clearance at page 31 page, date?
Date is, my lord, 25/2014.
Yes.
After getting environmental clearance, my lord, work order has been issued.
5 years.
Environmental clearance is only for 5 years. Then, my lord, they have entered into agreement. Settlement is going on. They have operating the Mohol, my lord. Then, my lord, lordship may come to kindly page 39.
39.
39, my lord. Renewal comes, my lord. Because, my lord, that is 14 to 19, that is 5 years gone. So, by letter dated 10/1/2020, they have prayed for renewal of the environmental clearance, my lord.
You had prayed?
Yes, my lord. 1 lakh rupees paid, draft of 1 lakh rupees paid, my lord. That is for renewal of 2 years, my lord. That is renewal for 2 years. The balance period, up to 21. So, that has not been granted immediately.
Yes.
Then, my lord, lordship may come to page 65. That is a letter by the petitioner requesting the renewal, requesting the sea authority to consider his renewal prayer and grant again, my lord, for the balance period.
Yes. Reminder.
Then, reminder. Then page 66 is also issued by the divisional forest officer, my lord, to the sea authority, my lord.
Okay.
That is also 22/1/2021. 22/1/2021.
Yes.
Then, my lord, the SIA authority granted that is, my lord, page 67, the renewal granted on 10/3/2021, and lordship may come to kindly page 74.
Yes.
That is, lordship will find that serial number 8. Environmental clearance is valid for 27/2021. That means 4 months, 10 days. So 4 months, 10 days, my lord. The environmental clearance is granted on 10/3/2021. Then to the that will expire on 27/2021. That is 4 months, 10 days.
Yes.
And that was granted, my lord, after a petitioner's application.
Now, what is your
Application was
grievance? What is your grievance, Mr. Sharma?
my lord, because of that, my lord, lordship, because of that, my lord, the mall was stopped by the DFO because there is no environmental clearance, so he cannot allow me to operate the mall, my lord. So accordingly, mall was stopped. And thereafter, my lord, after
But
getting
this renewal, your initial settlement for 7 years was also to expire on 27/2021.
21.
Accordingly, write the renewal on 10/3/2021. The same was done, made effective till 27/2021,
That
which is
means,
the
my lord,
last date of expiry. So
My
what is your grievance?
my lord, because of my application was, my lord, earlier application for renewal was on
That means from
10/1/2020.
10/1/2020
2020.
to
That means
10/3/2021, this
1 year,
period there
2
was
months.
no clearance. So you could not mind.
This period, my lord, we could not operate.
Okay.
Ultimately, no he also given, my lord, his money also given. Lordship will kindly see next. Then, my lord, lordship will come to page number 80. After getting this renewal of environmental clearance, my lord, the divisional forest officer directed me to deposit the 23rd kist. Up to 22 kist I have deposited and I have operated also.
Now what do you want?
Then lordship may kindly come to page number 80, my lord. That is
The first environmental clearance for 5 years was given on 25/2014, correct?
Yes, that
Till
is up to 19.
Till 19, from
Till 19.
25/14 to
19/5/19. That means 5 years.
19.
I have applied for renewal on 10/1/2020.
20. So effectively from 19/5/19 till 10/3/2021, you are not able to operate because of lack of clearance. That is your case.
Ultimately, my lord, page 80, lordship may kindly come to
80.
80. I have been directed by the divisional forest officer to deposit the 23rd kist.
80. Page 80.
80, my lord. Annex 9.
Yes.
I have been directed to deposit the 23rd kist. That is on 8/4/2021 and 19/4/2021, my lord, I have deposited.
The 23rd.
23rd kist.
Just a minute, please. We'll take a 5 minutes break. 23rd
23rd
East,
case, my lord.
you have paid.
My lord, paid.
So what remains to be decided?
It's a lot. Period for the 7 years period, which this was given to him. He only paid 23rd of the case. From 24 to the last 28, most likely he has not paid the case, Lordship. It's the fact that his environmental clearance was not granted by the CR, even though communication was made to CR, granted environmental clearance. Though that was not made, but that doesn't bar him to pay the case money, Lordship. Further, there's a provision if he is not being able to operate within that time frame, he can apply for renewal, Lordship, which he didn't apply in time.
No, but as a matter of fact, you need to clarify whether during this period when there was no environmental clearance, he was in a position to operate or not.
No, my lord, that was
Legally, he could not have operated.
my lord, report was there, my lord.
Though the settlement was for 7 years, clearance was for 5 years, admittedly. And in spite of reminders, clearance had come only on 10/3/2021. That means from the period of 2514 to when? Not 2514. 5 years. 5 years expired when?
5 years expired on, my lord, 19, 5, 19.
That means from 19/5/19 to
My lord, 10/3,
10/3/21.
there is no environmental clearance, my lord.
There was no environmental clearance. So
No,
if
that
there was
was
no
a-
environmental clearance, how do you expect lessee to operate and consequently to pay the kiss money?
In that case, if it's not being operated, there's a provision of surrendering the mining list. He could have surrendered the mining list under Rule 18. Even didn't do that also. He didn't apply
But
for.
the mining was, the period was up to 7 years.
Yes, it was 7 years, but if he cannot.
See, you not only the petitioner had written for given reminders, even you had written.
Yes,
So that can it be the only consideration that he had not surrendered the mining lease?
but since he was not being able to operate, and now he's taking a stand that since I'm not being able to operate, I cannot pay the kiss money.
Yes.
That's it. If he's not being able to kiss.
See, not being able to operate for some factual reasons is a different.
Yes,
Those will be, now he is not being able to operate because of a legal hindrance.
yes.
Legal hindrance of the serious nature, most serious nature, the environmental clearance was not granted. In spite of the fact that the lease period was for 7 years, in 14, the environmental clearance was for 5 years.
5 years.
Perhaps with the stipulation that by the expiry of 5 years, the other 2 years will be granted.
Yes,
But that took time.
that took time.
So why should you burden the lessee? Don't you think that it will be unreasonable?
Since after getting the environmental clearance, even he had deposited 23rd.
23rd,
kiss money.
yes.
Because if we look into the facts, before environmental clearance, he was not being able to deposit 23rd kiss money also.
Yes, 23rd he had
This
deposited.
was after getting the environmental clearance.
Yes.
If you look at the facts, even if he can deposit 23rd kiss money, so what the question comes is why cannot he give the rest of the kiss money?
He was not operating.
Even he was not operating before environmental clearance was granted. After getting environmental clearance,
So that is something which he'll arrange. But admittedly from 19/5/19 to 10/10/3/21, almost 2 years.
2 years.
There is no clearance, so no activity. How many keys are remaining as per you?
My lord, 23rd to 29th.
23rd you had paid.
Sorry, 23rd already paid, my lord. 24th, lordship, may kindly come to 95, my lord.
24th
24 to 29.
to 29th. This covers what is the what area, what period will it cover? Tenure?
My lord,
What will be the tenure?
1/4/22.
1/7/2021.
Hmm?
It covers the area for period of 1/4/2020 to 1/7/2021.
নহ'ব তাৰপিছত 20 হেৰিলৈ হ'ব এক্সপায়াৰী ডেটলৈ হ'ব
No, expiry is of 27/21.
Yes, my lord.
So it will be from 1/4/2020 to almost 27/2021.
27/21. No, there is a report submitted by the Divisional Forest Officer before the, my lord, additional Principal Chief Conservator of Forest.
Mr. Gogoi, let us balance the equities.
Yes, Lord.
You adjust the period when there was no mining environmental clearance. If after adjustment he is still liable to pay, then you can recover from him.
Yes, that can be used.
That will do. That will balance the equities. Otherwise, you cannot harass a citizen like this. And what about the, who's for the SIA? Anyone? Environmental clearance? Who appears? You only appear Forest Department.
No, see, CI is not forest department.
Here actually,
In other cases, you had appeared
No,
environmental forest state level. Okay, Likha. Let us have pass that order, okay? The instant writ petition instituted under Article 226 of the Constitution of India is for the following relief. Relief to put page to cycle, right? Page 24, campaign, relief is not trial about 20,
CI has not been made a party.
28. Full stop, para. Please have your seat, Mr. Sharma. As per the facts projected, comma, pursuant to a tender process, comma, the Bhimpara sand and gravel mining contract area was settled with the petitioner for a period of 7 years. Full stop. The said period was to expire on 27/2021. Full stop. It is, however, the case of the petitioner that environmental clearance, which is a mandatory requirement for such settlement, was given on 25/2014, which was for a period of 5 years. Full stop. Accordingly, the agreement was entered into between the parties and the operation had started. Full stop. As the environmental clearance after expiry of the period of 5 years was not renewed, comma, the mining operation had come to a standstill and the petitioner had issued issued representations on 10/1/2020 and 21/1/2021 for such environmental clearance. Full stop. The Forest Department had also issued a communication dated 22/1/2021 to the state level, state level something, page 67 of us. To the state level environmental impact assessment authority for such renewal. Full stop. Ultimately, the renewal was issued via a communication dated 10/3/2021 by the Environmental Assessment Authority, which was for a period of 4 months, 10 days, expiring on commensurating with the expiry date of expiry, that is 27/2021. Full stop. Para. It is the specific case of the petitioner that for the period 19/5/19 to 10/3/2021, due to absence of environmental clearance, no mining operations could be conducted, and accordingly, no kiss money could be deposited after the 22nd kiss money was deposited. Full stop. Wide the impugned order dated 8/4/2021, comma, the petitioner was directed to deposit the 23rd kist, and there was also a stipulation of a recovery as well as warrant of arrest against the petitioner in a Bakizai proceeding. Full stop. Para. This court wide order dated 24/5/2023, while issuing notice of motion had passed an interim order suspending the recovery as well as the warrant of arrest against the petitioner. Full stop, Para. I have heard Sri J. Sharma, learned counsel for the petitioner. I have also heard Sri R. Gogoi, learned standing counsel, Forest Department, and Sri M. Chetia, learned state counsel. Para. Sri Sharma, the learned counsel for the petitioner, has submitted that though the settlement was for a period of 7 years to expire on 27/2021, the environmental clearance was admittedly for a period of 5 years given by communication dated 25/2014, full stop. He has submitted that grant of such clearance was not within the control of the petitioner, and he was under a legitimate expectation that the clearance for the remaining 2 years would be renewed or granted in course of time, full stop. As such renewal was not made on time, the petitioner had made representations, including a communication dated 21/1/2021 by the Forest Department itself, full stop. He has submitted that the renewal was ultimately made on 10/3/2021 up to 27/2021, which commensurates with the date of expiry of the lease, full stop. He has submitted that after that during the pendency of the writ petition, the petitioner had also deposited the 23rd kiss money, full stop. It is submitted that due to absence of environmental clearance for the period 19/5/2019 to 10/3/2021, the petitioner was not able to operate the mahal, full stop. Para. On the other hand, Sri Gogoi, the learned counsel for the Forest Department, has submitted that in absence of environmental clearance, if the petitioner was not able to operate the mahal, the same should have surrendered, and the same would not be a reason not to pay the kiss money, full stop.
He can apply for renewal of the lease also.
He has also submitted that the rules contains provision as per which a lessee can apply for renewal of the lease in certain circumstances, which was also not done. Para. While from the facts and circumstances, it is clear that for the period 19/5/2019 to 10/3/2021, there was no environmental clearance, and it cannot be in dispute that in absence of such environmental clearance, a lessee cannot operate a mahal, full stop. The said bar is a legal bar which cannot be disputed, full stop. This court has also taken into consideration that the lease period was for 7 years as stipulated in the settlement order dated 25/9/2014, whereas the environmental clearance which was taken prior in point of time wide order dated 25/2014 was for a period of 5 years, full stop. It clearly appears that the further clearance for 2 years would be obtained in due course of time, full stop. However, there was a delay in the renewal of such clearance in spite of reminders by the petitioner and even by the Forest Department, and such renewal was ultimately done on 10/3/2021 up to a period of 27/2021, full stop. Para. Since the petitioner was legally barred from operating the mahal from the period of 19/5/2019 to 10/3/2021 due to absence of environmental clearance in which the petitioner would not have any effective control, the demand of KISS money for the period for the aforesaid period in question does not appear to be reasonable. Full stop. The initiation of Bakizai proceedings for recovery of the amount also would not be reasonable in the considered opinion of this court. Full stop. There's an agreement in the bar that the petitioner had paid KISS money up till the 23rd installment. Full stop. Upon consideration of the facts and circumstances and by balancing the equities, it is directed that while the petitioner would be liable to pay the KISS money for the tenure in question, the department would not insist upon payment of the KISS amount for the period 19/5/2019 to 10/3/2021. Full stop. The balance amount which would be required to be paid by the petitioner be deposited within a period of 3 months from today, if not already deposited. Full stop. Till if such balance is deposited, the department shall not proceed further with the Bakizai proceedings. Full stop. The interim order passed earlier is also made absolute in the terms of the observations made in the present order.
Obliged.
Proceeding, the provision of appeal against the notice issued by Deputy Commissioner. The petitioner can go and file an objection denying his liability. There is a provision of appeal, section 9.
It is also provided that upon payment of the balance amount, the parties may apply for dropping of the Bakizai proceedings in accordance with law.
Right.
I'm sorry, my lord, I was not there in the matter of fault. But this bank guarantee has been extended and the claim period is up to 15/7/2027.
15/7?
2027.
No.
Claim period. There is a coverage period which is up to 31/7/2026 and I've given a copy.
Let me obtain instruction. Let it come from because the letter is dated only 15.
Okay, Sri R. Dubey, learned counsel for the petitioner, upon instruction, has submitted that the bank guarantee has been extended. Full stop. Sri P.K. Roy, learned senior counsel for the FCI, praised for some time to obtain instructions on this aspect. Matter is accordingly adjourned to be listed on Friday next. Wednesday next, whenever you say.
Let it be Monday or Tuesday because Thursday we are out.
Wednesday?
Wednesday.
Wednesday.
Date to be Wednesday would be 22nd.
Yes. The interim order.
Interim order passed earlier. Stands extended till the next date of listing.
Deep level.
16.
Last order lotion में कल ही थी मतलब they have admitted their liability by an affidavit and say that in the register my serial number is 10.
We have to provided by the central government. The union will have to be made a party, but
But he said that it is not covered. If you remember correctly, yours was relating to the site office.
Site office only.
Not the
That
main
was
one.
given by PWD. Nothing to do with my lord.
But
Now,
here
central
clarified matter, it will be covered by the central government scheme. That's why we are.
Madam, they have given the work and the time of payment, they are shifting burden
The
to.
harm in my lord impeding the Union of India, my lord. So that at least my lord effectively the order of this honorable.
No,
court
no,
can be
Lordship, my lord,
implemented.
Government of India has specifically said that they will not pay it. That is an annexure, my lord.
No, we are, my lord,
That is,
corresponding with.
Lordship, kindly see.
Mr.
Page
Gogoi,
50.
you correspond and you get the funds. Why should you burden the petitioner? For a work which is the central government is not connected. It's not a necessary party, proper party, yes, but not necessary. They're not the funding agency. If you want the funds from the center, you write, why should you involve the petitioner in this complicated process?
Effective order. At least, my lord, they will be taken into.
What is your position, chronology?
10, my lord. 10, it's 1.5 year back, my lord.
It's still there in that position.
Same 10.
My lord, it is to the bill of 2014, my lord.
How does one proceed from 10 to 9 and 8?
Subject to
Lordship, may kindly see page 50.
Of your
That
petition.
the objection they are taking, my lord. Central government has said that you cannot get it. You have done on your own.
50.
50, my lord.
By whom?
By central government to the PW department. They clearly denied it. In this regard, your kind attention is drawn to clause 15 of the additional and special condition of the contract, which clearly stipulates that inter alia the cost of facilities of site office shall be inclusive of the bid value of the offered. No extra claim will be admissible. And then again, PWD took up the matter, said that no, some get.
The main work was not given to you.
Main work was given to someone else. And Lordship, kindly see page 49 also, my lord. 49, my lord, executive engineer took up the matter with the government of India, my lord.
Mr. Gogoi, you have to take further instructions. We'll make it very clear. Heard Sri B. Chakraborty, learned counsel for the petitioner, as well as Sri B. Gogoi, learned AAG, representing the Public Works Department, para. The matter pertains to a claim for release of contractual dues, full stop. It is contended that in terms of the decision of the Honorable Full Bench, in the case of Tamshir Ali versus State of Assam reported in so-and-so, the position, the petitioner was placed in a chronological list in the year.
But affidavit was filed on
Chronological list in which his position is against serial number 10. Full stop.
January 25, it was filed, my lord.
Serial number 10, full stop. On specific, on direction of this court to the learned AG to have instructions, comma, it has been provided that there is no change in the position and the fund would come from the central government. Yes. Full stop. Para. In this connection, comma, Sri Chakraborty, the learned counsel for the petitioner, has drawn the attention of this court to communications dated 15/6/2016 and 30/6/2016 within bracket annexures 5 and 6 of the writ petition, and has contended that the central government in clear terms has stated that all miscellaneous cost, including facilities like site office, would be inclusive in the bid value offered. Full stop. It is not in dispute that the principal work was granted to another contractor, and it is only in respect of the site office and other construction for which the present lease is pending. Full stop. Considering the above, comma, the submission made by the learned AG that the central government is required to be made a party as funds would have to be provided by the central government does not appear to be sustainable. Full stop. The claim of the petitioner has to be considered from the funds already made available towards the entire work which was sanctioned by the central government. Full stop. Accordingly, comma, Sri Gogoi is directed to take fresh instructions as to the manner by which the grievances of the petitioner would be redressed in a timely manner. Full stop. Para. List on, we'll have it on 17th of August. Okay. You have this order, then you can get it clarification.
I will.
The junior has given me only on F4 yesterday, Lordship. I have to take Lordship. I cannot take it. I have to take the instruction.
Alright.
Yes.
Why did you give the late, Mr.
Lordship,
Kothapur?
Lordship, I am sorry for that, your Lordship.
There is an urgency.
Yes, my urgency was there, your Lordship.
Have you participated?
Yes, your Lordship.
Heard 3 as Bothakur, Learned Senior Counsel for the petition, Para. 3 P. Sharma, Learned Standing Counsel, AFDC.
Fishery Department, Lordship.
Last time you have written the Learned Standing Counsel. Fisheries Department has, however, informed that extra copies were given. Only yesterday, and therefore, only yesterday afternoon, and therefore, he could not obtain the instructions in time. Fourth para. Under such facts and circumstances, matter is adjourned to be listed on Wednesday next.
I have to take in department, Lordship.
On
Lordship, if it can be on Wednesday, your Lordship, because.
Wednesday. Wednesday, you're there or not?
And they are, Lordship. They are in department, Lordship. They have to take.
Monday, Tuesday, Wednesday, 3 dates.
3 days.
Date is this the age of internet.
Lordship.
You need not physically go there on Wednesday. Wednesday. Interim order passed earlier to continue till the next date of listing.
I love that.
Now, do you have extra copies or not present today?
No. I have actually, initially, they have not given me.
That's I should have your Lordship.
Okay, yes.
Okay.
Next.
It is not extra copy, it is original.
18.
World Cup.
In this case, I am seeking some
Item number
18, my lord. Some short accommodation, my lord,
for
filing the rejoinder affidavit, my lord. Next week, my lord, if possible.
rejoinder was filed 1 year back.
Yes, my lord.
Why you need 1 year to file rejoinder
1
affidavit?
week, I'll file.
Who are you?
Lordship, I am appearing on behalf of Mr. S. Das, standing counsel for
AFDC.
ASIDC.
ASIDC.
ASID.
Yes.
You have filed your affidavit. You have filed your affidavit.
Yes, yes.
This 14 to 25 is your affidavit. 2, 3,
Yes.
and 4.
Yes, yes.
Okay. Heard 3 as Dr. Learned Counsel for the petitioner. Also heard your name?
A. Tarafdar, Lordship, appearing on
A.
behalf of
Talukdar.
Tarafdar.
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 A. Tarafdar, Learned Counsel appearing on instruction of 3 as thus Standing Counsel ASIDC. Within bracket response numbers 2, 3, and 4. He has submitted that affidavit in opposition by the aforesaid respondents by the respondent numbers 2, 3, and 4 has been filed on 14 to 2025. Para. 3. Dr. Learned Counsel has renewed his prayer for grant of time to file rejoinder affidavit. Para. As time was already granted earlier, further time of 2 weeks is granted to file rejoinder affidavit. Full stop. Para. List on 7th of August. You get sufficient time.
Yes, yes.
File it.
I'll file, my I'll bless.
I did my case.
Yes.
On 6/6/2020, 2005, I have opened a PPF account in the name of my HUF. And
Affidavit file, Mr. Chakraborty? You'd like to file rejoinder?
No.
Then we can take this up for disposal.
Yes.
Are you ready for disposal?
Short
Yes.
issues.
What is it?
my lord, Annexure B, page 25.
25.
This is the passbook.
You opened, what did you open? PPF?
PPF account in the name of my HUF. I have opened the account on 6/6/2005.
Is it permissible?
That's exactly.
Now,
After-
we came to know that it is not permissible.
But it was opened at that time.
It was opened, we paid for 15 years and they have accepted the amount. The date of maturity is on 31/3/2021.
31/3/21.
Well,
Date.
kindly produce the next annexure C, page number 26. This is a statement of account which they have issued.
Now what is their stand?
We're ready to give him the principal amount. No interest can be because it's void from the beginning now.
When was the circular?
13 amendment came in 13/5/2005.
When did you open the account, Mr. Kabra?
On 6/6/2005.
16?
June, that is June.
6 June 2005.
In the May lordship, the amendment came.
May 2005.
Yes.
13/5, exact date is 13/5.
In the statement of account, they are showing the interest in every year. I am depositing in the account. In every year, they are showing in annexure sheet, page number 26. Every year, they are showing the interest. In this way, I have deposited 17,40,000, and the interest they have shown is 15,93,217 as on 31/3/2022. After maturity, when I went there for encashing the amount, they said that there is a circular, you are not entitled for the interest amount.
But he was
No for
depositing.
claiming damages and all the fighting.
But he was there. You were accepting the amount.
All along 15 years.
Something void from the beginning, whether any liability can be custodied.
No, but yes, you are correct. A thing which is not permitted by law, you cannot recognize it. But it's not only the opening of the account. You kept on receiving the amount from every year, 15 years.
That's why we're ready
Now,
to pay the principal amount for them.
No, that is no submission that we are ready to pay the principal amount. Otherwise, that will be amounting to wrongful loss. It would be held for criminal offense, embezzlement.
Lordship, the interest cannot be given thing void from the beginning. Lapse of time cannot cure it, Lordship.
But will you recover from the officers? Why should he suffer? Recover from the officers.
Lordship, for him, let him.
No, why should he go to the civil court? He recovered from the officers.
And moreover, Lordship, the person has died. So all this legal certificate and all, or succession or.
Who's died?
In the name of whom the.
It was an HUF. The Carta probably have died. How does it matter? What HUF is a legal entity. Whether the Carta has died or not, Carta is only the person who will operate the HUF.
First procedure, because there is, we have stated in our affidavit, it has been referred to as a death claim also.
Why?
Maybe their procedure, that's page 54 of the affidavit.
54. Death claim. How is it death claim? See the name under which the account was opened.
The name is Savarmal
Khemka and Sons.
HUF.
HUF.
Yes. After that, I became the Karta.
How much is the interest component, Mr. Kapra?
15,93,217 as on 31/3/2022.
You recover from the officers. You pay and you recover from the officers. It's very well to say that something is illegal, but why did you keep on? First time you should not have opened. You cannot forcefully open an HUF account.
Earlier there was that agents were there, private agents were there.
Agents
Perpetuated by them.
Maybe, but while opening, agents will facilitate opening, but they will not open it. Opening will be by your PPF department, your post office. You have to pay the amount. Heard. three.
It may be come under the purview of consumer dispute also.
In similar circumstances, Honorable Supreme Court has decreed the amount. May I please?
Yes. In what proceeding?
Similar proceeding.
Proceeding, what is the proceeding? Is it writ proceeding or civil proceeding?
proceeding.
Writ proceeding.
Yes.
Let us see. Which one?
Second one,
Bhagavati.
Bhagavati Vanaspati, relevant para is para 9. In this case, the NSC was opened in the name of the firm. Then after maturity, they said that it is irregular. We cannot give you the interest.
Hmm.
Then the matter came before the Honorable Supreme Court.
Yes.
May I read?
Yes, please.
Para 9. It is indeed true that the NSC was purchased in the name of Bhagavati Banaspati Traders. It is also equally true that Bhagavati Banaspati Traders is a sole property of concern of BK Garg. As such, the irregularity committed while issuing the NSC in the name of Bhagavati Banaspati Traders would have easily been corrected by substituting the name of Messrs. Bhagavati Banaspati Traders with BK Garg. May I?
Yes, please.
For in a sole proprietorship concern, an individual uses a fictional trade name in place of his own name.
Mr. Cabra, this is not in a writ proceeding, it's a consumer proceeding. That is what we had asked. You said writ proceeding. It arose, it went up to the Supreme Court from a consumer
Consumer,
case.
yes.
But that will not be a bar for us to interfere. Then what has happened here in Vanaspati?
The rigidity adopted by the authority is clearly ununderstandable. The postal authorities having permitted Bhagavati Banaspati Traders to purchase the NSC in the year 1995 could not have legitimately raised a challenge of irregularity after the maturity thereof in the year 2001, especially when the irregularity was curable.
Where is the amendment, Mr. Chakraborty?
Page 49.
49.
Yes, Bhagavati Banaspati Traders. Modi. Supreme Court. May
Just a minute, just a minute. How much did you deposit, Mr. Cabra?
17,000,
17
17
lakh.
lakhs 40,000.
Deposited.
Yes. And as per the statement, interest portion is 15 lakhs 93,217 as on 31/3/2022.
17 lakh 40,000 would be the principal.
Principal.
And interest would be
15 lakhs 93,217. As per the statement, totaling an amount of 33 lakhs 33,217. As on the date of maturity,
33 lakhs,
33,000
33 lakhs, 33,000.
217.
Okay. Now, who's the Karza of the HUF?
Myself.
Son. His son has. Okay. Now, who's the HUF is the petitioner here.
Yes.
Amit Khemka is the present Karta. Okay. Where is the impugned letter of 23/10/2024? Page 41.
Page 41.
But Lordship, claim has been filed on behalf of Chanda Devi Khemka.
My mother.
In the parawise comment to your notice, where are the relevant discussion? At 42, irregular.
Basically, Lordship is stated that since 13/5/2000 after
Yes,
the
that
amendment.
is
it did not have
correct,
a
correct. Okay, please write.
So we said that we're ready to pay back the principal. Also, will note down my objection to this, to the alternative remedy.
Yes. Heard three, your Ekabra, learned counsel for the petitioner. Also heard Sri B. Chakraborty, learned CGC, representing the respondents. Para, the instant application has been filed under Article 226 of the Constitution of India, has been filed. Please have your seat for the following relief. Please put 20 Para, as per the facts projected, the petitioner is an HUF firm represented by the Karta, which had opened a PPF account, being account ID number 0057336275 and CIF ID number 004438983 in the GPO Gauhati. In the GPO Gauhati on 6/6/2005 for a period of 15 years, which was to expire on 31/3/2021. Full stop. The deposits were made every year till the date of the deposit, and accordingly, which were also accepted, and interest were shown to be accruing in the passbook /account statement maintained by the petitioner with the GPO. Full stop. After such expiry of the maturity on attaining the maturity date, a total amount of rupees 33,217 was shown to be standing to the credit of the petitioner as the total amount. Full stop. However, when the amount was demanded, the same was not paid to the petitioner on one pretext or the other. Full stop. Ultimately, the petitioner had issued a legal notice on 22/7/2024, which, however, was replied on not 10/8, but it should be 23/10.
10/8/2024.
Replied on
10/8.
10/8/2024 by submitting by informing that the account was irregular and no interest would be payable. full stop. Further correspondence by the petitioner had failed to impress upon the respondents to make the full payment, including the interest, and accordingly, the present petition has been
You were ready to pay the principal.
no, the interest, and accordingly, the present writ petition has been instituted. Full stop. Para. Sri Kabra, the learned counsel, has submitted that the account was opened in the name of the HUF, which itself is a legal entity, on 6/8/2005, and deposits were made in every year for a period of 15 years, and such deposits were accepted without any issue, without any complaint. Full stop. He has also drawn the attention of this court to the statement of accounts issued by the Postal Department, which has reflected the interest component accruing from year to year, whereby the total amount of rupees 33,33,217 was reflected. Full stop. He has submitted that from the correspondence exchanged, more particularly, the response to the legal notice would reflect that the respondents have taken support of an amendment made in the year made in May 2005, whereby PPF account in the name of HUF was discontinued. Full stop. He has submitted that though the account was opened subsequent to such amendment, the authorities, being fully aware, had opened such account, which was also followed by receipt of the yearly deposits for a period of long 15 years. Full stop. Under such facts and circumstances, it would be wholly unreasonable to deny the interest upon the amount. Full stop. In this connection, the learned counsel for the petitioner has relied upon a number of case laws, including the case of Mrs. Bhagavati Banaspati Traders versus Senior Superintendent of Post Office, reported in AIR 2015, Supreme Court 901. First, in the said case, an NSC was opened in the name of a proprietorship firm, and the interest component was refused on the ground of certain irregularities while opening such account. Full stop. The Honorable Supreme Court had, however, held that because of such irregularities, the amount in question cannot be denied to the account holder. Full stop. For any reference, the relevant observations of the Honorable Supreme Court are extracted herein below. Paragraph 9 in Nila Tahiri Dias. Side of Nilas. Para. Per contra, Sri Chakraborty, the learned CGC, has submitted that the department has never refused to pay the principal amount, and the objection is only with regard to the interest component. Full stop. He has submitted that wide the amendment dated 13 May 2005, there is a clear stipulation that PPF account cannot be opened in the name or in the name of an HUF, correct? by referring, full stop, by referring to the said amendment in the scheme termed as Public Provident Fund within bracket amendment bracket close scheme 2005, which has been enclosed in the affidavit in opposition dated 21/4/2026, the learned CGC has submitted that the stand of the respondent cannot be faulted, cannot be faulted with, full stop. He has also reiterated that so far as the principal amount is concerned, being rupees 17,40,000, the same is ready to be refunded to the petitioner. Full stop. Para. Anything else, Mr.?
And that maintainability.
Sri Chakraborty has also submitted that the issue could have been raised in a consumer forum and not in a writ court. Full stop. Para. The rival submissions have been duly considered and the materials placed before this court have been carefully examined. Full stop. Para. At the outset, this court would, dealing with the preliminary objection on the aspect of maintainability, this court is of the opinion that the jurisdiction exercised under Article 226 of the Constitution of India, being plenary in nature, it would depend on the facts and circumstances and plenary in nature, and to secure the ends of justice, and the facts and circumstances of the instant case would not, in the considered opinion, oust the petitioner from invoking the writ jurisdiction. Para. The projected defense, as revealed from the affidavit in opposition filed on 21/4/2026, is an amendment of the scheme made on 13/5/2005, full stop. Though the said scheme has omitted the expression HUF from the earlier scheme towards opening of PPF, indicating that after the said notification, no PPF can be opened in the name of an HUF, it is not in dispute that a PPF account was indeed opened in the name of the petitioner HUF on 6/8/2005, full stop. While opening such account, the petitioner would not have any control, and rather the respondents were the sole authorities which had consciously opened the account, full stop. The further fact is that for the following 15 years, yearly deposits were made, coupled with the fact that in the statement of accounts, the interest was shown to be accruing, full stop. The dispute had arisen when there has been a refusal to pay the matured amount on expiry, on fulfillment of the date of maturity, which is 31/3/2021, full stop. While the respondents are relying upon the notification dated 13 May 2005, this court is of the opinion that the account having been opened consciously, even after such notification, and the deposit amount received every year from the HUF petitioner, and interest also being reflected in the statement of accounts, comma, the mere irregularity in opening the account and maintaining the same would not be a reasonable ground to deny the interest component of the to the petitioner. Full stop. The Honorable Supreme Court in the aforesaid case of Gauhati Banaspati Supra had in a similar circumstance concerning opening of concerning of purchasing of NSC in the name of a proprietorship firm had directed payment of the interest component to the entity. Full stop. This court is of the opinion that in the present facts and circumstances, comma, the respondents would not be justified in taking the defense of the notification dated 13/5/2005 to deny the legal entitlement of the petitioner. Full stop. Para. The writ petition is accordingly disposed of by directing the respondents to pay the matured amount, including the interest component, to the petitioner in within a period of 60 days from the date of receipt of a certified copy of this order. 33 lakhs for you. You need 3 months. You make it 1 month. Post office. How many thousands of crores do you have? Within a period of 2 months from today. The writ petition is accordingly disposed of. It is allowed in the manner indicated above. Okay.
My lord, this matter I'm ready for 2 weeks time to obtain our instructions, my lord.
Lordship. Here the implementing agency, Lordship, it was done under the PWD department, Lordship. They have filed their affidavit, Lordship. They admitted that the petitioner has executed the work, Lordship, in question.
How much time, Mr. Barua?
My lord.
We grant 2 weeks. Okay.
Lordship.
Heard Sri B.K. Gogoi, learned counsel for the petitioner. Also heard Sri H. Barua, learned counsel representing the Public Works Department, and Sri J. Hendrik, learned standing counsel, Revenue Department. Para. On the prayer of Sri Barua, representing the Revenue Public Works Department, matter is adjourned by 2 weeks to enable him to obtain instructions.
Lordship.
We give a date
Lordship.
list on 31st of July.
Lordship. Oblige, Lordship.
Yes, Ali. Yes.
It's become infructuous.
Infructuous.
Period is already over.
Settlement period. Heard Sri M.S. Ali, learned counsel for the petitioners. Also heard Sri S. Dutta, learned standing counsel PNRD, and Sri M. Chetia, learned state counsel Para. It is jointly represented in the bar that the subject matter being connected with a period of settlement which is over, there is no live cause of action that requires any further adjudication. Para. In view of the above, both the writ petitions are closed.
Lordship, in this case, we have filed an affidavit in reply, Lordship, on 26 June.
You have filed?
Yes, Lordship, that is in not there, Lordship.
When did you file?
26 June, Lordship.
Okay. What is your name, madam?
K. Das, Lordship.
K. Das.
Yes, Lordship.
Miss, you are for whom?
Lordship, respondent number 4.
You have filed affidavit.
Yes, Lordship.
Who is for? Private respondent. Stockholding Corporation of India.
The manager of the store.
You want to, you have filed rejoinder to the respondent number 4 as affidavit. Miss K. Das.
Yes, Lordship.
Learned Counsel, your name is not there, madam?
Yes, Lordship, my name is not.
Ms. Kedas, Learned Counsel, representing, appearing on instruction of Ms. K. Devi.
Yes,
Learned Counsel for the petitioner submits that on
26 June, Lordship.
26/6/2026, the rejoinder affidavit has been filed against the affidavit in opposition of the respondent number 5, which however is not, respondent 4,
Respondent,
which however is not tagged with the records, para, office to verify and tag the rejoinder affidavit with the records and list this matter after a week.
obliged, Lordship.
27.
And also in terms of the last order, there was I think the report has come.
Otherwise, this matter become impersonal.
No.
But
Is it?
No, we have been given an extension. And we are still running it. The extension last was for 30th of June. I think they have now extended on a daily basis, I believe.
no, we're going to settle final settlement.
I see, okay, that is.
But the regular settlement period is over. It was 31st of March.
The issue,
Hmm?
jurisdictional problem is there between the.
No, if it has become academic, why should we decide it? We'll decide in an appropriate case.
Because last time also, my lord, the one order was there for to make money settle the issue. They are also not settled, my lord.
These are all on
This case
extension.
has been
So that has
come
to
up,
be
my
settled.
lord. Now also say, my lord, one order was there.
This is the extension period which has been granted. The extension which has been granted after 31st of March, there were two
No,
extensions.
it depends on you. If you say that we decide on merits, we decide after a preliminary review, of course. We have not, we do not know the facts, we do not recollect the facts. What were the facts? There was
Yes, Manoj can decide this issue because every time this problem will otherwise arise as to who will have a jurisdiction in that.
Now, who will bell the cat? Is it required to bell the cat? 3824. This is that list to name. You can fill the tender process.
Yes, an additional affidavit, my lord, it can look.
There is a clash between the Panchayat and the IWT.
You see, correct. So this report specifically says.
Who will run the.
You go outside, have a cup of tea and settle. Mr. Datta.
Till now it is settled with me, so rest I don't know how they want to go.
Ms. Bora and Mr. Datta, a cup of tea and settle. Or coffee rather.
Main problem is at field, my lord, not here.
At field.
Yeah,
Measurement of this.
because as per our.
Decisions are not made on the field. Decisions are made in the coffee table. You sit across and decide and convey.
My lord, as per direction of this court, my lord, one verification was done, but now we have received complaints, my lord, that was not properly done.
But is it required to decide in this matter? This matter has, otherwise also will not. Your period is over.
Over.
31st March.
His period is over.
No, I was operating till 31st of March, then
Yes.
subsequently all extensions. This is the last extension which has been granted now. Temporary extensions which have been given to us.
Temporary extension till you make a final extension.
Yeah.
Now these are, once the final extension is done, if the matter still persists, the issue still persists, we'll decide. Huh? If after the new settlement, if the issue persists, we'll decide in that matter.
My lord, what happens normally, my lord, because 30th June is the last page. In exchange of pleadings, my lord, always, my lord, it's becoming influential. It's going like that on. So lordship may direct the district commissioner, my lord, he is the best person to
Verify.
verify, man. Yeah.
SA Commissioner, yes, Mr. Chetia.
He's on neutral also.
Huh?
He's
Neutral,
neutral party
because
also.
department on last occasion.
He's not even aware what is going on.
After observing that, lordship to dispose of
He is maintaining a policy of non-interference. Your dispute you decide. Why should I come in?
Honorable Court has directed the Commissioner Secretary to present a report. This report is before this Honorable Court. We have filing on additional affidavit, page 64.
Okay, you also take instructions, Mr. Chitia. You take instructions. We will also take into account the consideration, the report, and try to decide.
Yes.
Okay.
Would be better.
Lordship, may direct the Deputy Commissioner.
Is the DC, Deputy Commissioner, District Commissioner? Huh? Not
I
a
don't think
party.
they are party, my lord.
Huh?
They are not a party in this.
So why do you involve him then? Unnecessary.
Direct the Commissioner Secretary Transport to look into it.
Transport and Panchayat, why don't you sit and talk?
My lord, that was, direction was already there.
Then what happened?
After verification was not done. That is the properly.
No, you can take into the aid of the District Commissioner and get the verification done.
Yes,
That observation
That-
may be.
Yes.
Uh,
Lordship, it would be better. Give direction to both the department to sit over the. Look into the matter.
To the district commissioner.
To the district
I don't,
commissioner.
disposal is that easy. Without applying mind, we dispose of.
Let Lordship, this matter become impact, sir.
The petitioner has challenged my lord the settlement of Gauhati.
Hmm.
30th June, that is already open. Because beyond Panchayat, you cannot settle.
Only the point of jurisdiction, this matter is pending before this Honorable Court.
And I'll decide in an appropriate case. Let us close this then.
Yes, my lord.
Sri R.B. Fukan Leonard Senior Counsel, assisted by Sri K. Mohammed. Also heard Miss M.D. Bora, Leonard Standing Counsel, Transport Department, Sri S. Doctor, Leonard Standing Counsel, PNRD, comma, Sri R. Sharma, Leonard Counsel for the respondent number 10. Full stop. As per the facts projected, the petitioner was settled with the Milpara, Tapabodi, Kalajal, Mora Nadi Par Ghat by the Inland Water Department wide and order dated 38/2024, which was up to March 2026.
Yes, ma'am.
In the meantime, comma, the Hajo Anchalik Panchayat through Hajo Anchalik Panchayat and the Kamrup Jila Parishad had issued a settlement order for the same Parghat wide and order dated 16/12/2025 in favor of the respondent number 10. Full stop. The primary ground of challenge is on the aspect of jurisdiction. Full stop. While the petitioner contends that it is the IWT which will have the jurisdiction to settle the Parghat and is also supported by the Transport Department, comma, the Panchayat Department submits that such contention cannot be readily inferred in view of the powers and jurisdiction conferred on the Panchayats by the Act. Full stop. It, however, transpires that the impugned settlement dated 16/12/2025 in favor of the respondent number 10 has come to an end in June 2026.
30.
On 30th June 2026. In view of the efforts of development, comma, this court is of the opinion that the adjudication of the issue involved has been rendered mere academic. Full stop. Para. In view of the same, comma, writ petition is closed by leaving the question open, leaving the question to be decided, a question raised in this petition open to be decided in an appropriate case.
There is an additional affidavit which my learned friend has filed, my lord, and there's a report on record. Ashish may say that that report has already come in terms of the previous direction, because that report will be very important. My lord, what has happened now is, now the respondent number 10 has been given on a daily basis, has been given that, or that the operation of running in that period. So there'll be a clash now. This report which has served terms and given in terms of the previous direction. So this is already says that this is with so and so. So there's already a finding now. That's the difficulty, my lord.
Now you, if your business is hampered by the daily, the arrangements given to the respondent on daily basis, make a fresh challenge. We'll decide. We'll decide.
I'll leave that to your lordship.
What is the IA about?
They have filed that I.
For? In view of
Written
the
interim
final
orders,
orders
ma'am.
passed in the writ petition, comma, no orders are required to be passed in the IA, which accordingly stands closed.
There was an interim order passed by your lordships only. That was-
Interim order, what the main interim order passed in the interim order, interim order stands vacated with the disposal of the writ petition.
Great.
Lovely.
29.
I have to file an reply, my lord. So 2 weeks time may be granted.
Reply to whom?
This
R5.
excise department.
R5.
Yes.
Who's R5?
No, reply to the excise department, my lord.
But R5 has filed affidavit. Who is R5? Superintendent of Excise.
Yes.
R5 only?
Yes,
Who is
R5.
representing the Excise
N.
Department?
Goswami was there. I have already taken the consent. He is out of station today, probably.
Okay.
He informed me,
Oh,
my lord.
okay. On the request of Sri B. Chetri, learned counsel for the petitioner, matter is adjourned by 3 weeks to enable filing of rejoinder affidavit to the affidavit in opposition of the respondent number 5.
Lord.
Para list on 10th of August 2026.
Great, your lordship. Well, on the last occasion, my lord, a notice was issued in this matter. And today the matter was fixed for consideration of interim order, my lord. The matter relates to, my lord, debarment of the petitioner for 1 year.
Yes. Who is your senior? P. Sharma. Which department?
PWD, my lord.
Public Works Department, not your matter. Public Works Department.
Item 33.
Extremely sorry.
Doesn't matter. For Public Works Department, Mr. Chaudhary. We had stipulated that we would consider the interim prayer today.
Lordship, here, Mr. Igogoi is appearing. Lordship may take it up the time.
Debarment. Authorization violation করেছে। আর আমি
Basically, my lord, the Director General, R&D and SS is the competent authority. At
Can I
page
have it
number-
after a while, Mr. Gogoi? Please inform Mr. Gogoi.
May it please the lordship. So I pray, my lord, further, my lord, 2 weeks time, my lord. Yesterday I received, my lord, they says that affidavit that particular area, we are not under the jurisdiction of FDC. And in the meantime, receiving my one letter, my lord, this is the under, my lord, FDC. If I reply at least.
On the
10
prayer
days.
of Sri N. Bora, learned counsel for the petitioner, matter is adjourned by 3 weeks to enable him to file rejoinder affidavit. First up, we give a date, Mr. Bora, list on 7th of August, is it okay?
My lord. My lord.
55.
Look, I had a conversation with the DC.
Oh, yes, yesterday's matter.
Yes, sir. I had a telephonic talk with the DC. He informed that the final order is being passed today. He's in the process of passing the order.
Final orders of what? Cancellation?
Not-
No,
This will be very vague, neither here nor there.
No, on 24/4, lordship, if lordship kindly comes to the doctor. There, the petitioner has already submitted that notice to the notice, they have already replied. In the process, that process is going on.
But suspension maximum 90 days.
Suspension.
So we interfere with the suspension order. It
By
depends on,
operation of law, it is, if
but it depend on, will be subject to whatever you, what you have to restore it.
Suspension and cancellation, two different things.
That is it.
In fact, in the, what I have received the instruction that it is after this, after the notice follow, they are going to take the final decision today.
Whatever decision you take
Ah.
will finally govern. But so far as suspension is concerned, which is the issue before us, we say that 90 days, it has expired, spent its force. You have to restore him, subject to what decision you finally take.
Certainly. And
That's
it
all.
is something like legal fiction, my lord.
Yes.
And it is the duty of the honorable court to give effect.
Since they are in the process of passing the order today, can we wait till Monday, because ultimately.
See, it's not, we are not deciding this case on the verge of expiry. The order of suspension had spent its force of 90 days
On
in
3rd of July.
in June,
3rd of July.
3rd of July. Now sufficient time has passed. Had it been on the verge, we might have given you 1 or 2 days. Whatever decision you take finally on the aspect of cancellation or otherwise. Okay. Heard Sri K. N. Chaudhary, Learned Senior Counsel, assisted by Sri R. M. Deka for the petition. Also heard Sri D. Nath, Learned Senior Advocate, appearing for the contesting respondents. Readings have been exchanged, and considering the subject matter involved, comma, the writ petition is taken up for disposal at the admission stage. Full stop para. The challenge is against an order dated 4/4/2026, by which the fair price shop license,
No, my lord. LPG.
LPG distribution, as LPG, what do you call it?
Retail outlet. LPG distributor.
LPG distributorship of the petitioner has been cancelled. Full stop para. As per the facts projected, comma, while the petitioner was running the business of LPG distributorship, comma, the impugned order dated 4/4/2026 was issued, whereby his trade license was suspended. Full stop. Though the impugned order had referred to certain complaints, comma, it is the case of the petitioner that he has not been served with copies of any such complaints. Full stop. It is also contended that the petitioner was not given an opportunity of hearing before the order of suspension was issued, which amounts to seriously, adversely affect his rights and having civil consequences. Para. Sri Chaudhary, the Learned Senior Counsel, has submitted that there is also an apparent non-application of mind to the order, O capital, order of 1982, holding the field, inasmuch as the suspension has been said to be ordered as per the powers vested by clause 8, full stop. He, however, submits that even if it is assumed that it is under section 11, under which the suspension has been ordered, comma, under section 11 subclause 2, or not section, clause 11 subclause 2, 11 within bracket 2, comma, such period of suspension cannot exceed 90 days. And it is not in dispute that such 90 days was over on or about 3/7/2026. Full stop para. Per contra, comma, Sri Nath, the Learned Senior Advocate, has submitted that in the meantime, proceeding was initiated and is on the verge of completion. And as per verbal instructions received by him, comma, final orders would be passed today, within a day, within a day or two. Today,
Yes, sir.
within a day.
It will be finalized today.
Pass shortly, full stop, para. Without, after hearing the Senate counsel for the parties and without going to the aspect of an opportunity of hearing, if required, before such order of suspension is issued, this court is of the view that, is of the opinion that in view of the categorical requirement of law under clause 11(2), that a period of suspension cannot exceed 90 days. And admittedly, no further orders having passed towards cancellation or otherwise of the license of the petitioner, this court is of the opinion that such order of, that the impugned order of suspension has spent its force on or about 3/4/2026. 3/7/2026, full stop. In view of the above, the impugned order dated 4/4/2026 is held to be non-extant law from 3/7/2026, and consequently, the license of the petitioner is liable to be restored. Full stop. The aforesaid direction, however, would be subject to final orders that will be passed in the proceeding by the appropriate authority, which is required to be communicated to the petitioner in accordance with law. And बोलो for respond number 4 to 6 important लिख दो.
Financial week खुली लेना. Over the
Item number. Item number.
My lord, here, my lord, a tender was issued by, my lord, the NF Railway Authority for providing housekeeping services to particular trains, my lord. Now, in the process of finalizing the tender, my lord, the authorities have committed certain infirmities, my lord, that I would like to point out. Now, if
Mr.
your
Gupta,
lordship-
you are for the railways.
Yes.
So it can be taken up for disposal today.
Yes, a very short point, my lord. Yes. If your lordship would
Housekeeping services are in
the train, I'm giving the train, my lord. Integrated housekeeping services of Brahmaputra Mail and any express. Then page 114, my lord.
Is there any housekeeping in those two trains?
Actually, my lord, they provide those bedrolls and all that. That is the
Are those
service.
provided? We have had plenty of experience in both these trains for a long time. Personal experience.
In those days, it was not there, my lord. Those days, we used to carry that pillow, air pillow.
And one more, Avadasam. Avadasam, no one ventured, but these two are very.
Done it, my lord.
But these two are very
I
well.
was kicked out in Rangia, my lord. I was thrown, my lord, virtually.
But these two are very popular, especially Northeast.
Okay. Northeast and Tinsukia Mail, my lord.
Tinsukia is Brahmaputra.
Brahmaputra. No, there was a train called Tinsukia Mail.
This has become Brahmaputra.
Acha. I still remember 160 rupees was the fare. 3 times.
1953 kilometers. I remember the distance.
That short ticket, my lord.
1949 or 1953.
Whether Mr. Chaudhary is there, Vikram Kotgalnai. My lord, in the premises where Vikram stays, there was a gentleman called Nirada Bhuya. He was the head clerk. So we used to buy ticket from his place.
In the railways.
But it was fixed for everyone in the family and neighborhood. He is the main person.
He was the man who used to prepare the chart. So 2-3 days ahead, we'll go on such and such that. He says, you come at so and so time.
Yes, please. Then housekeeping.
Yes. Page 114, my lord.
Yes.
Now we are concerned with the schedule 2, my lord. Provision for bonus. My lord, it so happens, my lord, while quoting the bid, one has to give the quotation for, my lord, bonus also. LS provision for bonus to staff with GST. So the amount indicated was 1 crore 34 lakhs 90.
Page 114, which part are you schedule?
My lord, schedule 02.
Schedule 02.
The dispute is with regard to this, my lord.
Provision for bonus to staff.
Yes. The bidder, while quoting his bid, my lord, is also required to quote this at par. Now, my lord will kindly come to page 117. On top, 12, 13 and 14. Bonus at the rate of 8.33% of the minimum wages, whichever is admissible as per the Bonus Act, made by the contractor for Coach Mitra staff. So they are called Coach Mitra staff, supervisor, shall be reimbursed to the contractor only after submission of proof that it has been credited to their account, subject to eligibility of the staff for payment of bonus as per the prevailing Bonus Act. Now, this is important. The bidder should quote at par against the item number 1 of schedule 2, the rate schedule. Quoting below par against the bonus item will lead to summarily rejection of their offer. In case of any rebate offered by the bidder over goods quoted value, each individual item will be examined considering rebate percentage. In such case, if the quoted value including the rebate percentage against schedule 2 is below par, then their offer will summarily be rejected. Provision for bonus made in the tender is lump sum, as actual bonus amount is not accessible at the tendering stage and can be ascertained only after execution. As there are possibilities for a particular skill and highly skilled category staff for working less number of days on average per month to not meet the monthly wage of 21. In such case, the particular staff, even skill, high skill, will also be eligible for payment of bonus as per the Payment of Bonus Act. Thus, provision of bonus for all category of staff has been incorporated in the tender, whereas payment to be made on actual basis as per feasibility of payment as per Bonus Act. The bidders are advised to quote at par against bonus item will all possibilities for ensuring smooth compliance to the Act. So, my lord, my humble submission would be, my lord, reading clause 12, 13 and 14, what clearly emerges is that so far as the, my lord, amount of bonus part is concerned, as contained in schedule 2, it has to be quoted at par. And what is the at par item? If we come back to 114 once, my lord,
yes,
it is 1 crore 34,98,565.
correct.
Now, my lord, will kindly come to page number 152. This is the, my lord, financial bid summary.
152.
152. Now, my lord, will kindly see Urmila is one respondent number 4 in this case, my lord, and it has been adjusted as L1. And last column, my lord, Tharu Sons Ernakulam, I am the petitioner, my lord, I am L2. Now, if your lordships will kindly come to the schedule 2 towards the bottom of the page, and let's see, my lord.
This 152 is the what? Comparative table.
Is the comparative statement, my lord, following opening of the price bid.
Okay.
Now, kindly see, my lord, the amount is 118 at page number 152 towards the bottom, my lord.
152, yes.
Now, schedule number 2, the rate of respondent number 4 is 18 crore 19 lakhs 24,416, and the rate of the petitioner is 18 crore 4 lakhs 761. Am I clear, my lord? As far as schedule 1 is concerned.
Which
These are the
page are
rates
you,
of schedule 1.
which are you referring to? Page?
Page 152, Milord.
Yes, 152.
Towards the bottom.
Yes, rates are all the same.
No, schedule 1 rate, Lordship will kindly see heading in the bold letters part.
Yes.
As far as Urmila is concerned, it is 18 crore 19 lakhs 24,000.
416.
Yes. Then on the last column, Milord,
Yes.
I am the petitioner.
Okay.
I am less.
Yes.
I am 18 crore 4 lakhs 76,139.65.
Urmila is the private respondent.
Private respondent.
Number?
4.
Okay.
Now please skip over to the next page, Milord. Now regarding schedule 2, it starts at page 152, Milord. Now kindly see LS provision for payment of bonus to staff with GST. Respondent number 4 has quoted not at par. He quoted 1 crore 36 lakhs 7,903, whereas all other bidders, Milord, has quoted at par. The prescription in the NIT is, Milord, that you must quote the bid at par. So all bidders, in fact, they're following all throughout the country, Milord. They file an additional affidavit to bring on record those aspects, Milord. Now what the respondent number 4 did, Milord, he purportedly gave a so-called rebate of 0.80. That is how now he has become L1. His rate is, Milord, 19 crore overall, 19 crore 39 lakh 68,061.93, and that of petitioner is, my lord, there is a difference of, my lord, 19 crore 39 lakhs 74,705.26, roughly about, my lord, 6,000 rupees.
6,000.
Yes. Now, my lord, merely because he has not quoted that part. Now, my lord, it's a tender. Here, my lord, Maxwell's interpretation of statute or any other things should not be brought in, my lord. Simple thing is, my lord, transparency requires that we give a literal meaning to the things, my lord. Now, if we bring here Maxwell interpretation, then things maybe do not know to what will it go end up, Miller. So therefore, when the tender condition says that it must be submitted at par, it should be at par. Let us not bring in all these, Miller, calculations and computations and permutations. Now, end of the day, what had happened is, we have explained in our representation, that is the position, Miller. If your lordships would kindly come to page 146.
146.
Yes. Now, kindly see, my lord, as towards the bottom of the page, as per schedule number 2, provision for bonus to staff 1 crore 34 lakhs 98,000. This is as per the NIT. L1 has quoted 0.8% above. So it was, my lord, 1 crore 36 lakhs 7,000 and odd. Then they have given a rebate of 8%. Therefore, it comes to, my lord, 1 crore 34 lakhs 99,040.76. So it is more by rupees 475.15. So it is not at par. So our simple case is, my lord, when you should keep things very clear, and we should not, bring in some indirect way of doing things. Is it not a case, my lord, in the process a hidden criteria has emerged? Because, my lord, the tender conditions very clearly says that what you quote for bonus, it should be at par. Now you are not quoting at par, you are quoting higher amount, then you are giving bonus, then it eventually boils down to it is 4.75. Now the stand of the railway is, NIT does not say that it cannot be less. Stand of the railway is, my lord, they have not quoted less than, they may have quoted more. So my lord, is that the rationale, my lord?
It is in the range of the bonus.
And end of the day, my lord, payment of bonus will depend on several factors. First of all, we will have to satisfy the authority that this bonus has been paid. Number two, that the person to whom bonus is being paid, he is entitled to bonus, and all these things are there. But to keep the things very simple and clear, my lord, the tender inviting authority insisted that whenever you quote rate for bonus, it should be at par. Now you are bringing in certain method, introducing some hidden criteria. So therefore, my humble submission, my lord, the stand of the railway that they have not quoted less. There is no bar to quote more. So that is the stand
No,
of
what we have understood.
Yes.
See, bonus has to be calculated at 8.33%.
Yes.
And they have stipulated that for bonus, you cannot tinker.
Yes.
So you have to be on bonus, the competition will not be on the aspect of how much you give as bonus.
Yes.
Bonus has already been
It's a
stipulated.
statutory prescription,
Statutory
it is governed by the statute.
8.33, it will be 8.33, nothing more, nothing less.
Huh.
So the competition is not going to be decided on the basis how much you quote
Quote
on
for
bonus.
the bonus, absolutely.
The competition would be based on the bid.
Yes,
on other components, that what is your rate. Now on the aspect of bonus, if the respondent 4 has given something which is not prescribed by the
Exactly.
NIT, how do you
That is our simple case.
how do you accept their bid, Mr. Gupta? Admittedly, bonus they have said something high. You cannot play with the bonuses. You may give high on your own, but that will not have a determining factor so far as the competition is concerned.
The requirement of the tender conditions, my lord, which now is in sort to be interpreted, my lord. The intention of the tendering authority that should prevail.
Yes.
And the
Your intention is at par.
At par.
At
If
par means
somebody
cannot means higher.
If somebody quotes above par,
Yes.
it will not lead to rejection, my lord.
Why?
That is not
Have you
the-
stipulated?
Yes, ma'am.
Where have you stipulated in the tender?
Takes page 119.
119.
Rates. Paragraph 4, my lord.
119.
Page 119 at the bottom.
Yes.
The rates.
Yes.
4.1.
Yes.
Contractor should quote percentage at par, above, below rates on the schedule.
Yes.
So, my lord, in respect of schedule 1, schedule 2, my lord, the contractor is given liberty, he can quote at par, above or below.
Yes.
So far as bonus is concerned, my lord, at page 117,
Yes.
the requirement is, my lord, clause 12, that says, my lord, bidder should quote at par against item number 1 of schedule 2 of the rate schedule. Quoting below par against the item will lead to rejection.
Yes.
So, my lord, that requirement, that quoting above par will lead to rejection, is nowhere there in the tender condition. And no prejudice is caused to the petitioner, my lord, here. And if, my lord, the L1 has quoted a higher rate, my lord, 0.80, my lord, still he is L1. If, my lord,
See,
it is
this
the overall
interpretation would be would come into play when you reject somebody who has quoted above, then he comes to the court. That their interpretation is also possible. Now, if you have to give that interpretation, it will mean favoring somebody which is not contemplated by the conditions of the contract.
No, my lord, the condition of the contract
No,
nowhere.
no, please, Mr. Gupta, please try to understand. If this would have come from a bidder who quotes a higher rate, saying that there is no bar in quoting higher, then matter could be considered by this court, not from your side. You are the owner. You have to stipulate.
But I will also produce the, my lord, the minutes of the tender committee wherein the reasons are given.
Then ultimately, what is this kind of a gimmick? 0 point rebate and higher 0 point ultimately same. He's only playing with this figures to come out L1.
No, my lord, the requirement is, my lord.
No, what is this? What is this? Quoting something above the requirement, then giving a rebate.
That is a provision is there for giving.
Provision not for rebate, for bonus.
It is there, my lord.
Not for bonus.
It is paragraph.
Not for bonus. This will be against your condition that you can quote above but not below. You cannot give rebate for bonus. Bonus is a statutory requirement. It will not come in even within the aspect of deciding a competition.
My lord, the reasons which, my lord, I have, my lord, the minutes of the tendering committee.
Lump sum bole koi dise. It clearly says it is lump sum. clause 14.
If my lord sees clause 5.3,
Play page. Page.
page, my lord. 7 page 7, my lord. It's not numbered, my lord.
Page 7 of your affidavit.
Of the minutes of meeting I have given. Minutes of
You
the
have
tender
produced
com-
this one.
Minutes of the tender committee proceeding, my lord.
Where have you given? This bunch.
Yes, ma'am. Yes. This is the minutes of the tender committee dated 11/4/2006. At page 7, there is a discussion, my lord, on the compliance compliance to bonus items.
Where?
5.3, my lord. It is, I have highlighted it, my lord. Page 7.
5.1.
5.3.
5.1, 5.2, 5.3. Yes, discussion on compliance
Compliance of
to bonus
compliance
items.
bonus items.
Yes, what is
As
this?
per note 12 at page 92 of schedule of rates, it is mentioned that the bonus at the rate of 8.33 of minimum wages, whichever is admissible as the bonus act, made by the contractor for coach mitra staffs and supervisors, shall be reimbursed to the contractor only after submission of the proof that has been credited to their account, subject to eligibility of the staff for payment of the bonus as per prevailing bonus act. Bidders
Yes.
quote at par against the item number 1 of schedule 2 of the rate schedule. Quoting below par against the bonus item will lead to summary rejection of thereof.
Yes.
Now further, my lord, as per note 13 of page 92 of schedule of rates at page serial number 179, in case of any rebate offered by the bidder over gross quoted value, each individual item will be examined and examined considering rebate percentage. In such case, if quoted value including rebate percentage against schedule 2 of the BOQ is below par, then their offer will be summarily rejected. In the tender, the provision for bonus made in the tender is lump sum, which will be reimbursed to the contractor only after the submission of the proof
Yes.
that it has been credited to the account subject to eligibility. As per, now this is important, Lord. As per the Bonus Act 1965, Section 11, payment of maximum bonus permits the allocable bonus surplus exceeds the amount of minimum bonus subject to maximum ceiling of 20% of the salary or wage. The said provision has also been reiterated by Region Level Commissioner, not order dated 5/9/22. Thus, the critical threshold for rejection under the bonus criteria shall be any financial bid submitted by a firm quoting below minimum bonus prescribed in the tender, that is below par or below 1,34,98,565. The minimum bonus has been derived on the basis of the vetted estimates and supporting analysis available in so. So, there is a reason this tender committee, there is a basis, my lord, for arriving at a conclusion. It is not that the authorities have arbitrarily, my lord, come to such a conclusion. The minutes of the meeting clearly
So
says,
what prevented you from stipulating that the bid for bonus should not be less than this amount? You have time and again said it has to be at par, it has to be at par. Then suddenly you change your stand that above will be acceptable, below will not be acceptable.
not suddenly, my lord, the minutes of the tender
No,
committee.
this is suddenly only on the discussion part.
My lord.
In the document which you had floated, at least on 2 occasions you had said it should be at par, it should be at par. Anything which is not at par would be rejected.
Yes, my lord. But
Then you
if it is
take.
above par, it will be rejected.
So
Nowhere
what
it is
prevented
there.
you? What prevented you from stating in the affidavit that this component has to be either at par or above, not below?
It is there.
No,
My
it's
lord,
not
at
there.
Below par is there, my lord, page 117. In case the quoted value including rebate percentage against schedule 2 of BOP is below par,
Par, yes.
then their offer will be summarily rejected.
Rejected.
That's a special condition
Yes.
incorporated. So nowhere it is there, my lord, that above par will lead to rejection. What prejudice is caused to the petitioner, my lord? If someone quotes above par, where is the prejudice caused to him? In fact, my lord,
Mr. Gupta, that submission will not be accepted. If you stipulate that you have to bid at par of what is the amount, What prejudice you are saying? They could have even given a higher offer so far as bonus is concerned.
But even after giving the higher offer, the overall total bid value, they are still L2. In that way, if I quote a higher rate.
No, they so far.
Presuming L1 quotes a higher rate, he will, rather he should be at, even after quoting the higher rate, he is L1.
No, we are L1.
He is L1. Even after quoting the higher rate, he is L1.
Let us see the comparative statement again.
Yes, page 152. Kindly see, my lord, on the other aspects, I am the L1. He is 1 crore, 18 crore, 19 lakhs. I am 18 crore, 4 lakhs.
So far as schedule 1 is concerned.
Yes.
And schedule 2 is the bonus.
Schedule 2 is the bonus.
It is the net value which has to be seen, not the individual items. Total net value offered,
Net value is schedule 1 and schedule 2.
Yes, these are the two
the
rates.
total at page 150.
Schedule 1 and schedule 2. And is there any other?
Yes.
What other?
The total of the both, schedule 1 and schedule 2, that comes to 19 crore 39 68 061. And in respect of the petitioner, it is 19 39 74 705.
Another article.
And that is after giving the voting above par.
Rebate enable.
So far as rebate is concerned, rebate the contractor can give, there is a provision under the contract to give rebate. They have not given that rebate.
Without rebate, his rate is 19 crore 55 lakhs.
Yes.
And our rate is 19 crore 39 lakhs.
This rebate is given at what stage, Mr. Gupta?
Well, at the time of bidding, submitting the bid money. At the time of submitting the bid, that is there in the the managed. They have not given that rebate, at this stage now, they are saying, they will give the rebate. So unless there is any malapride-ness or arbitrariness, the tender conditions cannot be interpreted in their own way, such unsuccessful bidder.
Your discussion in this case is 152 and 153, the first part only, isn't it? So far as the others are concerned, I think those are not relevant. Mr. Gupta?
Yes.
153, the first table itself.
And at 153 also.
And at 153, which ends at net other value. So far as the first is concerned, this is R4, I think, 1939 68 061.
Yes.
R4 Urmila.
Yes.
And petition is 1939 74.
After rebate, still the.
We'll have this for some other day. We'll Mr.
I'll
Gupta,
just
can you
point out one thing.
can you just get this proper prints in a better format?
My lord, I'll get it.
It's too small for us to read.
We may be also given a copy, my lord. It's not classified
But
document.
we'd like to give some time to this matter.
Okay.
But next week itself, or next Wednesday. Tuesday we have fixed many matters.
Wednesday.
But at least the relevant pages, please magnify it and get it. Okay, this is very difficult for us. Uh,
My lord, we have annexed some
But
tenders.
we need some clarification, Mr. Gupta. First, we have understood your submission that there is no stipulation that it cannot be above par. That you need to substantiate. Number one. In substantiate, so far as your expressions are concerned, in the initial part that at par is required.
No.
And there is of course a summary rejection because if it is below par, whether it can mean that somebody can quote above par. Now, we also want to know the mechanism at page 153, how bonus has been quoted by the respondent 4 above par and rebate has been given, and finally the bid appears to be less than the bid of the petitioner by 6,000 or whatever. And if you take into aspect the bonus part which has to be par, then petitioner clearly appears to be L1. We want to know this arithmetic, how is it done?
And before bonus, my lord, respondent number 4's bid value is 19 crore 55 lakhs.
Yeah, that we have
Whereas
seen.
ours is 19 crore 39 lakhs.
39.
And secondly, my lord, we have annexed few tenders issued by other railways, my lord, that the explanation no, below, above, and at par only. Why NF Railway has not used this? Because these are these issues, my lord, which creates all this problem. You are keeping a place for your leg room.
Those are different tenders.
What different tenders? Same tender.
Same ministry.
Same railway ministry. It's not a question of interpretation of the tender. It's not that employer is trying to interpret something, we're trying to say something. We say go by the literal meaning.
Okay, we will have it on Wednesday. Okay. Heard Sri K.N. Chaudhary, learned Senior Counsel, assisted by Sri G. Rahul for the petitioner. Also heard Sri H. Gupta, learned CGC, appearing for the railways, and Miss name B. Talukdar for the respondent number 4. List for admission hearing on Wednesday next. Is there any interim order?
No.
Who's running the show now?
During the pendency of the case, I think a work order has been issued. Na?
Okay. An endeavor would be made for disposal of the matter on the next date fixed.
Item 33.
Well, I've got the paragraphs from it. I pray for time till Monday to file the affidavit. Lordship will take up on Tuesday or Wednesday regarding my practice.
No, but authority is the central government office.
Director
What
General.
jurisdiction will you have, if you remember correctly?
Yes.
Let it be on Monday. I have not gone through that parawise. I will file it by the let it be on record. Lordship can file final order.
Okay, then Wednesday. You file it by Monday? Heard Sri K.N. Chaudhary, and Senior Counsel, assisted by Sri R.M. Deka for the petitioner. Sri B. Gogoi, learned AAG, representing the Public Works Department, has submitted that instructions have been received and he would file an affidavit immediately. Let such affidavit be filed immediately and the matter be listed on for consideration on Wednesday.
Goodbye.
You meet that criteria, that requirement. Otherwise, we may not be required to go into the other aspects.
I'm paying on behalf of respondent number 6 some time, file my lord petition for stay vacating.
You'll file stay vacating application. For that, you need not seek time. It's your prerogative.
My lord, let it fix on 27, my lord. Before that, I'll file.
We vacate this day. Why should you trouble Mr. Agarwala?
You want to file an application? I want to file.
There's no requirement to file application. You have said we'll vacate this day. He is also not satisfied in the state. Okay, had
We have some tentatively on Friday.
You have also, Mr. Agarwal also got urgency, stay, there is a stay order.
My lord, I have some.
How soon can you file the affidavit, the application?
File by Monday.
Monday.
Wednesday.
Then Friday we'll have it,
My lord, I have personal result next week, my lord.
whenever you say,
Next Monday, my lord.
Next Monday.
27.
27th, okay, 27, Mr. Chaudhary. For Sri T.J. Mahtal and Senior Counsel, assisted by Sri A. Barua for the petitioners. Also heard Sri B. Chaudhary, Learned Standing Counsel, Public Works, Public Works Department.
I'm preparing for five.
Sri I. Ahmed, Learned Counsel for the respondent number 5, and Sri R. Agarwala, Learned Counsel for the respondent number 6 are present. Para. Sri Agarwala, the Learned Counsel has submitted that he would file appropriate application for modification, alteration, vacation of the interim order within by next week. Full stop. As agreed to by the Learned Counsel for the parties, list on 27th of July 2027, along with I, if so filed.
I have also instruction to file appropriate application.
Both hole likhiba. Both Sri Ahmed and Sri Agarwala pray for, huh? You also file it by the next week, and 27th. Para, last one, interim order passed earlier. Stands what? You have already accepted.
Yes, my lord, I have a good case, my lord, because record is very much necessary.
Stands discontinued.
No, it will continue, my lord. My case continue.
Stands extended till the next date of listing. But next date we are going to vacate it.
But after hearing.
And allow your writ petition.
Yes. No, my lord, record is very much necessary. Let him produce the record.
What is the matter about?
Matter, my lord, the tender matter, my lord, my technical bid has been rejected on the ground that I have not digitally signed. That is the only case. But if I am not digitally signed, it cannot be, my lord, uploaded in the portal, my lord.
Yes, records. What tender?
Road construction.
Road and bridge. How have you accepted the bid then if it was not signed technically, digitally?
He has submitted some of the bidding document, basic the standard bidding document where the conditions are that has not been digitally signed.
You get the records?
Yes,
because more than the stand of Mr. Agarwal or Mr. Ahmed, it's your stand. You have to defend your decision. They are only the beneficiaries. Okay.
Deeply.
Items 4 and 25.
This cases, my lord. I have received some instruction, my lord, what happened after the passing of the document, my lord. And in the meantime, we have filed the review of the original judgment also, my lord. One already filed yesterday, my lord, and one we are going today, my lord. Lordship may grant some time so that I can file affidavit regarding the report of the compliance of the contempt case, my lord.
But review isn't it time barred?
My lord, actually, the direction, my lord, for verification was to the district level only. After the contempt matter only, my lord, we came to know, my lord. Because the original direction was to district level, my lord.
Why after the contempt matter you had come to know you are not parties in the writ petition?
Originally, we have parties, my lord.
Then
we have sent letter to the district for compliance of the order, my lord. Thereafter, my lord, in the district level, my lord, they have erroneously admitted the matter, my lord. Thereafter, we come to know, my lord. That is why we have filed review. We have explained all the delay, my lord. Why?
when have you filed?
My lord, yesterday I will mention in the Monday, my lord.
We'll have this along with the review then.
Yes, ma'am.
We'll not adjourn this just like that. Heard Sri Kondokar, Learned Counsel for the. You are in both the matters.
Both the matters.
Also heard Sri S. Datta, Learned Counsel for the respondent numbers.
145. 145.
145.
No, 45.
4 and 5. 4 and 5.
4 and 5. Who has submitted that during the adjudication of the writ petition, certain important aspects could not be brought to the notice of the court, and therefore a review application has been filed yesterday. Full stop. Also heard Mr. Nath for Sri M. Nath, learned counsel for the Senate counsel for the response number 1, assisted by Sri A. Bhattacharjee. Here for Sri J. Handik, learned counsel for response number 2, and Sri and Sri G. Bokolial for one of the respondent. Para? Matters accordingly stand adjourned to be listed along with the review petition said to have been filed. Full stop. When can we have?
Why not on next Friday or Wednesday? Man?
You get it listed.
Yes, yes. I'll mention
Or
it if not.
if you want, you can mention. We'll allow your mention.
Yes, yes.
Okay. You make a mention. We'll.
Why not? Hello.
And
Item 26.
yes,
Yes,
Mr.
my lord, it's a contempt case, my lord, non-payment of the dues to the petitioner, my lord. So on the last occasion, they are supposed to submit it before the new budget session, my lord, and submit a report before this board.
Fortunately, the part payment has been made.
Yes.
And the remaining part, we have applied for a financial sanction.
Part payment has been made.
Yes, on,
And for the remaining part,
We have made a proposal for financial sanction. We may need some time.
financial sanction will be granted by whom? Finance Department.
We
Mr. Chalia, you're there.
I'll just take a copy of this and I'll expedite the.
We have
Okay, heard Sri B. Das, learned counsel for the petitioner. Para, your name?
our son on behalf of the Naglosh.
Your R?
Our son.
Please, you. Sri so learned counsel appearing on behalf of the respond numbers
1 and 3.
1 and 3 has submitted that part payment has been made, and for the remaining part, the finance department has been moved. Full stop. Para. Sri A. Chaliha, learned counsel for the respond number 3, has prayed for some time to get further instructions. Full stop. He also undertakes to give necessary instructions for expediting the matter.
The proposal has been sent. This is like the last page.
Okay.
So,
Expedite the matter. Para, in the interest of justice, matter is adjourned to be adjourned and be listed on 17th of August. 17th August, Monday. Yes. But get it done within 17th.
Item 27.
I may appeal, Lordship. Similar facts and circumstances, my lord. Already one case is dismissed, but liberty to the petitioner to file application before the competent authority seeking separate location, my lord.
Separate location?
Yes.
IMFL?
My lord, it's a gift shop, my lord.
But your Rivan says that your application was already filed before the sonar.
Yes, yes, my lord, that is pending, my lord.
Yes.
That is pending, my lord.
So what direction do you want now?
My lord, then my application may be disposed of within the time limit, my lord.
No, where are the respondents?
Within the time limit, my lord, my representatives may be disposed.
Who are the respondents? Yes, Mr. Bokolial.
A municipality. A government advocate will have a deputy commissioner related. 37.
You have not taken steps for 3 and 4.
My lord, as per my instruction, my lord, 3/9/2024 steps taken.
You have not taken steps.
Then, my lord, I may be allowed to, my lord, 2 days time, my lord. On Monday, I will take it.
Where is the order dated 29/4/2026 of the learned Lazima Court, as per which press steps upon the respondent number 4 was not taken, full stop. Subsequent office notes also reflects that steps as directed were not taken. Para 3 A.M. Ahmed, learned counsel for the petitioner prays for and is granted 3 days time
Yes.
to take fresh steps for service of notice upon the respondent number 5
4.
respondent number 4 by speed post with AD placed after 4 weeks along with fresh service service report.
Obliged.
Pendency shall not be a bar for the appropriate authority to consider and dispose of the representation of the petitioner in accordance with law.
Obliged.
My lord, this is a review application, my lord, on 2nd April, my learned friend appeared. He has also filed, my lord, objection also filed, my lord. Let it be on a hearing date, my lord. I have
Review, why review?
Review most probably, my lord, that order 41 rules 27 petition was not heard along in the, it was filed, they have taken time for filing application, objection, but no objection filed, but it was disposed of, my lord, without hearing.
Lordship, order 47 rule 27 petition, they have filed and they, since this honorable court did not dispose of the matter, so for that the reason they have come for review petition. But my humble submission is that review petition is not maintainable, because review petition can be entered when there is a error on the face of the record. There is no error at all. This honorable court has rightly passed the order.
Was there any discussion in the order
Yes,
regarding consideration of order 41/27 petition?
Yes, sir, that was
That-
the discussion. Page 18. Lordship,
18.
page 23. Court has discussed this. This honorable court has discussed it.
Yes, page 23, para 23, my lord.
And the case of prisoner Bush of this court.
No, there is nothing here.
No, my lord, I'll argue on that point, my lord, your lord, that's why I'm submitting. my
No,
lord.
no, review, limit, our scope is very, very limited.
No, that is the crux of the matter, my lord, because your lordship kindly see,
You go for an appeal.
my lord, that,
We dismiss this.
no, your
If
lord.
there was no consideration, we thought there was no
No,
consideration. We have
that-
considered,
no,
we have
your-
taken a
your
view, our
lordship
view may
kindly
be
see,
wrong.
That is not on,
Our view may be wrong.
no, that's correct. No, my lord, this is the crux of the matter, because the certified copy, we have produced the certified copy, that now we got the original copies. That's why I'm filing the application in when in the appeal.
That was also, they have filed this after long 14 years.
No, that's
The-
my suit was allowed. So far, I concerned, I have not gone through the, my lord, address aspect, my lord. So let it be on Monday or Tuesday, my
No,
lord.
no, we are not going to entertain this. You are not serious. I hear silly. I hear silly.
Yes, sir.
Where is the eye?
No,
No, I here, not here. I in earlier, my lord, in language, the 2nd appeal, my lord.
They contended that I was not disposed of.
No, I don't tussle any.
So I filed an objection also regarding the review petition.
We are dismissing this. Heard. Three TJ Mahanto.
No, my lord, that 23, my lord, that discussion, your lordship kindly see.
No,
my-
that discussion may be erroneous.
My lord,
Let us assume it is erroneous.
but no order passed on, my lord.
We have discussed what is required under 41/27. If you are aggrieved, you can file an appeal. How do you come and review? Heard Sri TJ Mahanto, learned senior counsel, assisted by Ms. P. Bhattacharya for the applicants. Also heard Ms. What is your name?
J-Paul.
Learned counsel for the J. Paul, learned counsel for the sole respondent. Para? by the instant application, comma, the applicant has prayed for review of the judgment and order dated 26/20/24 passed in RSA 112 of 2009 by the said order, comma, the appeal was dismissed and the substantial questions of law were answered accordingly in favor of the respondent in the appeal. Para. Sri Mohanta, the learned senior counsel, has primarily argued that along with the appeal, there was an application filed under Order 41, Rule 27 for taking evidence by the appellate court. Full stop. He has submitted that the said application was not considered in the proper perspective. Full stop. He has submitted that if the said application is allowed, comma, there would be a marked change in the decision to be taken in the appeal. Full stop. Para. Per contra, comma, Ms. Paul, the learned counsel for the petition for the opposite party, has submitted that the application under Order 41, Rule 27 CPC was taken on board by this court while disposing of the second appeal, and accordingly, there are no grounds for preferring a review. She has also submitted that the jurisdiction to be exercised by a review court being limited and circumscribed, comma, no case for interference, no case for invoking such jurisdiction is made out. Para. As noted above, it is the primary ground of filing this review is non-consideration of the application under Order 41, Rule 27 of the CPC. Full stop. Para. This court has, however, noted that in the judgment dated 26/20/24 rendered by this court, comma, in paragraph 23, there is a specific discussion on the said application, including the law laid down by the Honorable Supreme Court. Full stop. For any reference, the said discussions are extracted here in below, paragraph 23, page 18, Agor judgmental. Para. After deliberation of the matter and hearing of the parties, the order, aforesaid order, a judgment and order dated 26/20/24 has been pronounced. Full stop. Para. The scope of invoking review jurisdiction is circumscribed and limited to the parameters laid down in the relevant provisions in the CPC. Full stop. In the instant case, comma, as mentioned above, comma, apart from the ground raised not being factually correct and there being discussion on the application filed under Order 41, Rule 27 of the CPC, comma, the grounds urged would not come within the purview of the grounds envisaged to invoke review jurisdiction. Para. In view of the above, the review application stands rejected. Kamlesh to deliver.
May I please, Your Lordship?
Contempt.
Non-payment of.
Notice was issued. Have you taken steps?
Yes, Lordship. Water exchange report meant respond.
Office note dated 19/6/2026 reflects that neither ready card nor answer notice has returned back from the sole respondent. Full stop. Notices were issued way back on 1/3/2025. Is the sole respondent existing at the same post?
Their information we don't get.
Para, your name?
This, yeah.
3D Sukia Learned Counsel for the petitioner. 6 times to ascertain as to whether there is any change in the incumbent and thereafter change in the incumbent. Full stop. Let this matter be listed after 2 weeks. Whereafter this court will consider regarding taking of fresh steps. You just check whether the incumbent is still holding that office. Okay.
41 is same.
19/6 specialty office, no? Yes, sir. Sir.
42.
Mr. Sharma,
File take instruction, I provide the instruction.
here for the sole respondent.
Sole respondent, Lordship.
Okay. Sri P. Sharma, Learned Counsel, has appeared on behalf of the sole respondent and prays for 3 weeks' time to file affidavit in opposition. 4 weeks' time to file affidavit in opposition. Para, list on 19th of August to enable filing of affidavit in opposition.
43.
43 years.
May it please your lordship? Your lordship, the affidavit in opposition has already been filed.
Filed.
Yes, your lordship.
When?
Your lordship, this week, we have already received the copy, your lordship.
Who was appearing?
I'm paying.
When did you file it? You should write the date of filing in your copy. Why don't you write the date?
13/7/2026.
13/7. Miss M.K. Brown, Learned Counsel for the petitioner, submits that she has received a copy of the affidavit in opposition said to have been filed on 13/7/2026. Full stop. Sri P. Sharma, I also heard Sri P. Sharma, Learned Counsel for the sole respondent. Para. The affidavit said to have been filed is, however, not tagged with the records. Para, list after a week along with the affidavit said to have been filed. We'll give a date, list on 27th of July.
Obliged.
46.
40?
May it please your lordship. May it please your lordship. Your lordship, in this matter, the respondent number 3, district commissioner has filed an affidavit in opposition, your lordship. We need 3 weeks' time to file our rejoinder.
Who has filed R3?
Yes, your lordship.
R3 affidavit, when did you file?
Yesterday.
Yesterday. Who's for R3? You are for R3. Mr. Bokolial, you have filed. Mr. Chaudhary, you are for whom? 7 you have filed already.
Your lordship.
6, who is 6? 6, you are for 6.
Your lordship, we have filed a rejoinder to the affidavit in opposition of respondent number 6 and 7 yesterday as well. That is not on record, your lordship.
Okay. While the petitioner has filed rejoinder to the affidavit in opposition, affidavits in opposition filed by the respondent numbers 6 and 7 yesterday, comma, the Learned Counsel for the petitioner 6, 3 weeks' time to file rejoinder to the affidavit in opposition filed by respondent number 3. 3? Bukolial? 4, madam.
No, your lordship, this respondent number 3, district commissioner. Respondent number 3, your lordship.
3, Mr. Bukolyal, 3. 3.
Six.
Uh, list after 3 weeks to enable exchange of further pleadings.
I'll place the record. It
Okay,
was
cool.
there in the earlier order.
We have a date list on, yes, Mr. Chaudhary, a convenient date list on when? So 14th of August? Is okay, Friday. 14 August?
Deeply obliged.
Yeah, Lordship, as per office note, there is 14/7 service is awaited, Lord.
Regarding whom?
Regarding the association, Karmasari,
No, which one? Which respondent?
respondent two.
Office note dated 14/7/2026 reflects that notice upon the respondent to was dispatched on the said date only. What's the para? List after 4 weeks along with fresh service report.
Interim to continue.
Interim order passed earlier to continue till the next day of listing.
Able.
You're challenging award of labor court?
Not award, Lordship, industrial tribunal's order, Lordship.
Order? What kind of order?
By that order, 5 lakhs cost has been imposed to each of the opposite parties.
Why?
Because the issue was that whether the decision of the management to discontinue a pensionary benefit is legal or illegal. So while trying this, the petitioner in item number 47, warranty appeared and said that we have already handed over the garden to the petitioner in the 48 company as per the agreement. So thereafter, the tribunal asked both the parties how you sold the garden and submit all the documents. Without deciding the main issue, he directed the petitioners to, if the petitioner failed to produce the board resolution and etc. So a cost was imposed to each of the petitioner 5 lakhs, and then matter was referred to the company special tribunal to investigate, and also registered a money execution case by himself.
Which tribunal?
Industrial Tribunal, Dibrugarh.
Same in both the case?
In both the case.
Okay. Same R5?
R5.
R5 neki bolu? R2?
R2.
R2. Okay. Yes.
4 weeks.
4 weeks.
Obliged.
58 of the list.
Gimana, sir?
Always on the last day I had placed the incorrect instruction, Lordship.
50?
I placed the incorrect instruction on the last day, Lordship.
Yes, yes.
Yes,
Oh.
The
What
correct,
is-
the correct instruction, Lordship.
Yes, what is it, Mr. Sharma?
Lordship, I have talked with my client at 1 PM, Lordship. He has not received my instruction, he has not received them.
It was sanctioned on the 14th of July, Lordship. If Lordship take
Okay,
notice.
recent.
Lordship.
Oh. Pursuant to the last order dated 15/7/2026, Sri N.R. Sharma, Learned Counsel for the respondents, has taken fresh instructions and has submitted that due to inadvertence, an incorrect submission was made before this court based on the instruction in another matter. He has, however, submitted that fresh instructions have been taken as per which, pursuant to the judgment of this court, financial sanction
So this is only the financial sanction, Lordship. They have not paid the amount till that, Lordship, to my.
has been made for payment of the amount to the petitioner. He accordingly prays for, the said financial sanction appears to have been made on,
14th of-
where do you get?
Second page, Lordship, the second page of.
On 14/7/2026, para, in view of the aforesaid development, comma, matter is adjourned to be listed after 4 weeks, on which date the updated instructions are to be obtained by the learned counsel for the respondent.
Well,
We give a date, list on, we'll have it on 24th of August. Yes. And what has happened here?
My lord, I have the orders of the learned recovery officer.
Any development?
Your Honor, he's fixed it again on the 23rd of July next week.
Why?
We have filed our written submissions in the matter. However, the bank is yet to file, there was a change in counsel, they're yet to file a wakalatnama and the RO has
Your Miss Amdas.
Yes,
Amdas,
yes.
Miss Amdas, learned counsel has presented before this court copy of the order sheet of the learned DRT number 2 Kolkata, as per which the case has been fixed on 23/7/2026. Para. Also heard Sri M. Sharma, learned counsel for the bank, respondent bank, no, petitioner bank. Para. In view of the above, comma, matter is adjourned to be listed on. Can we have it on 12th of August? 12th of August, on which date, comma, updated instructions are to be obtained by the learned counsel for the parties.